Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
There's an search on February 28, 2020, 7:44 p.m. How, period, does the FBI find people? The people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy.
All right, I'm sorry. I'm a little bit late back. I apologize. I was over on Brandy Churchville's channel. It's a big day. Brandy hit 15,000, just barely. It was fun to be there and watch the numbers roll over. There's a huge gifting chain going on right now, and if you have it in your heart and in your wallet to join that chain, I would love it if you'd go over and just pop in and see Brandy and give her a little thumbs up. She has been dealt a hand that no one wishes they had. She's handling it with grace. She's amazing. We love her. We love what she does. We love the community she fosters. So if that's something that you're able to go and contribute to, please do. Give her a big thanks. 15,000 is a huge benchmark. We're so excited. I don't know why, but for me, 15,000 was like the hurdle, trying to get over that hurdle. Once it made that hurdle, things like sped up. I think it changes in the algorithm or something. Yes, my eyes are very sweaty right now. I've been trying to dry them a little bit. Very sweaty here in the studio. Watching Brandy hit 15,000, it is awesome. And watching the generosity of the community support her and cheer her on is wonderful. Thank you. As we have, if you look in the community over there and you look on the list here, we see a lot of the same names. We have just good people on both sides, and I couldn't thank you more for supporting that. She is amazing. So, yeah, we're all crying. No one's paying attention. There's like a surveillance video testimony being shown on the screen behind her, and we're just watching Brandy and watching the numbers, and it's awesome. Thank you so much for doing that. It means a lot, not just to me and to Brandy, but it also helps the LawTube community when you support the creator that does such a good job, and she does a fabulous job. The research she puts in, the charts she makes, it's wonderful, and she's fun and funny, and she takes us on walks on the beach. I mean, what more could you ask, really? Kilakina09 gifted a membership. Thank you very much. That went to Michelle M. Congratulations, Michelle M. We are coming back in this trial here. We are let's see. Golly gee, it's not my story to tell, but she dealt with cancer in the past, and she's got another scare going on right now that could be related to that. Doing some preventative and some treatment to hopefully not have it go down the same route that she went before. So just. What is Brandy's channel? It's right here. Let's see if somebody can type !Brandy. There it is. Her channel is right here. So in chat, that is the link to get to Brandy's channel. Brandy is wonderful. She's covering a different case than us right now. She's covering the Chaconis case, which is a different one, but it's great. We try. I was actually talking to Brandy, my wife, and I talked to her over the weekend. Just called and just to check on her a little bit, and we try to cover different cases so that you have some options and variety, because I know sometimes the case I'm covering is not the one you want to watch, and sometimes the case she's covering is the one. She's got some good ones. We have some good ones. Occasionally we cover the same case, but we try not to do that. We try to coordinate a little bit, but yeah. Her heart is on her sleeve today, as she's. It's not my story to tell, but she is going through some very, very tough stuff, and the support you give her it means the world to her right now. So that's all I can say. Thank you very much. All right. Yes, so happy she reached 15K. It took forever. It seems like it was just going so slowly, and then watching that last 100 subscribers come in today, because that basically it was on. I think it was about 100 that came in today. It was really neat, and then it just like snowballs and it grows. So really exciting. Thank you for subbing to her channel. That is wonderful. She's an amazing creator, And she loves the community she has over there is very much like the community we have over here. She does little things a few different. I don't have the Trial Daddy's calendar. There's some things that I don't do that she does. But she's wonderful, and she's just a good person. So happy to shout her out, and I'm so glad to know her. All right. Let's see. We're about to come back to court here in the Treehouse murder trial, where the jury has been sent home for the day, but we're not done with the action. There's actually going to be something spicy that happens, or I think it's going to be spicy, because there's going to be some argument about what testimony is going to be allowed in today. You know what I forgot? I know what I forgot, and I know SF in Texas knows what I forgot, because I forgot to properly recognize SF in Texas for being first in chat. SF in Texas, thank you very much for being first in chat. That is no small accomplishment. There's quite a few people vying for that position every time we go live, and today it was you. SF in Texas, congratulations. Thank you very much. With that congratulations, though, there is also a punishment. You can't just come waltzing in here and say what you want first before anyone else without getting punished, and that punishment is we sentence you to owning the internet for the rest of the day. So the internet is all yours for the rest of the day to take care of and maintain. So good. And if I haven't told you, we got our phone number back. We got it back. They got it back. They didn't make me jump through any hoops. I had an email from like corporate executive. It was like some way up in the channel. And they didn't call us. They just fixed it and sent an email that we fixed it. Like nobody wants to talk to me because I was so demanding last time. Anyway, thank you. So you don't have SF in Texas. You don't have to worry about my phone number. It is working now. Although now we're getting phone calls from the person who had my phone number for the last 2 weeks. So, yay. All right. Is Brandy covering Karen Reed? Yes, she will be. She's covering the Karen Reed trial. And that is, I say will be, but I honestly still have my doubts if that moves forward. I think there's still a chance that this whole thing gets dropped. And I realize I'm in the minority there, maybe thinking that might happen, but yeah, that's still, this case just seems bizarre, even more bizarre than this Treehouse murder case. Big shout out to Brandy. Thank you very much, Melanie. It was awesome to see that roll over on the channel live. Yeah, it's really, really cool down there. Can we turn off slow mode, please? Let me see what it's set to right now. We might be able to adjust it a little bit if the mods don't kill me. Let's see. Let's turn it down a little. How about right here? The problem is we have it makes it easier to I turned it down quite a bit. And they're probably going to kill me. See, G4 Outdoors says, I'm only at 30,000 subs. I could use some help. That is awesome. That is awesome, G4 Outdoors. We all could use some help a little bit. Let's see, where was it? I was saying something and I forgot. But okay, slow mode's turned down for a little bit. Once the crowd starts coming in, we're going to have to turn it back up just because it's hard work on the mods. Sure, I saw that. I was over there just for the switch and saw the train rolling in. Got to put a quick super chat in there myself, just thanking her. But she's amazing. She is just amazing. So let's see. I agree. She's a beautiful human. She really is. So I appreciate you guys supporting her. Just for those that have been supporters of her for a long time, they know to some degree what she's been through. She's shared some of it at different times. It's been rough. It's been really, really rough lately for her. And so I can tell you, having talked to her just on Sunday with my wife, I think it was Sunday, might have been Saturday. It's hard. She's going through some hard stuff. And, the future is uncertain. And there's all those worries and concerns and everything, the fears of what happened before and what happens and what ifs. And it's hard. It's hard to do that. I wouldn't trade places with her. It's terrifying what she's going through, but she's doing a great job. She's doing it with grace. So thank you very much. All right, I'm glad we could send a few people over there. If you weren't familiar with her already, she is the best. All All right, we're about to get started here. We've got about 2 minutes before court begins. So just as a reminder, when court begins here in the Treehouse trial, it's going to be a little bit different. The jury has been sent home for the day because Mr. Tucker was not able to get any additional witnesses today. They had conflicts. There was difficulty. Some of them don't want to come down, honestly. It sounds like Seth doesn't want to drive all the way. He's probably on the other side of Florida or the other end of Florida. It's a long drive, and he doesn't want to come down for 10 minutes of testimony and then turn around and drive back. He probably doesn't want to come down at all. But Mr. Tucker needs to have him authenticate some documents. It sounds like those are going to be related to the motion to suppress or motion to squash I can't remember the term, Travis's testimony, where he wants to withdraw that testimony. It says it was under duress. But so that's going to be interesting. It's going to be interesting, especially if the judge allows that in and allows that to go that way, because then it really calls into question the only real witness the prosecution has that points the finger of blame at Mr. Tucker. And so if they're able to bring that in, where he himself says that should not be a valid confession because it was under duress, I was basically forced to say that. Then at that point it's almost like a get out of jail free card. So we'll see if that goes that far. All right. Yeah, 3 minutes was a long time. I tried to turn it down just for a little bit. If it gets crowded in here, we'll have to add it up, turn it up a little bit. Yes, G4 Outdoors. It's the term that a lot of content creators use is grind, because it takes constant work maintaining a channel and growing a channel, as you know. But I have to tell you that it is the most fun work I've ever done, and I've loved every minute of it. It's been an amazing year. All right, Melissa, still not getting notifications. Carolina 5-0. Hi, RA. Hope you and your family are well. Have you heard anything else in the Woods case out of Person County? No, I haven't. That's one I have not kept up on the radar. Let me do a quick check. That should be going forward. Well, man. The Person case, Woods out of Person County, for those that aren't familiar, as we just take a brief squirrel tangent. That's the case where there was a family, I believe a mom, dad, and a son, like a teenage son, walking along on the side of the road. A car was driving by, a truck was driving by. It was a corrections facility truck from the jail or the local prison. And the truck struck and killed the son. The driver, who was a corrections officer, stopped, because it was, my understanding, it was an accident. The driver stopped. The driver and the dad got in an altercation, and the driver was killed there on the road. There was a fight, possibly a shooting, and the driver was killed. And then the mom and the dad hopped in the corrections truck and drove off and left their son's body and the corrections officer's body there on the side of the road. A little bizarre on that one. Hello, this is RA. Hello. Hello. Can you hear me? Man, I think that was a scam call. I answered it too soon, but let's see. All right. Now it's connected. All right. Anyway, I'll have to look at this and see what's up with the Woods case. Let's see, what Treehouse murder trial day was best for visual evidence like maps, videos, etc. There wasn't a ton of that. We've seen a couple, but the evidence has been this courtroom is a little bit backwards. Okay, first of all, they did the key lime. It's just a step above avocado colored walls and carpeting. I realize the courtroom's about a dozen years old, but the court in itself, the evidence has been often printed off on like 8.5 by 11 pages and just handed to the jury. So there isn't a ton of that. We sort of have to cobble together our own efforts in Google Maps and some internet pictures that are available to really understand the area. Let's see. Let's see. Brandy says, hi. Many of us popped in once you mentioned her. Thank you, Cachette. Appreciate that. I was there on the break. I wanted to see what was going on. Lynn Walters, welcome to the gallery. Great to have you as a new member here. Thank you so much. A couple of you are watching 2 channels at the same time. I love it. As you can see, I've got like my 8 boxes that I watch up here at the same time. I know what you're going through. Sometimes you're adjusting the volume, trying to listen to 2 things at once. Multitasking at its best. L Diamond says, what? You didn't pay your phone bill? No, it wasn't that. It was somebody else ordered a new phone number and another company, not mine, gave my phone number to their customer. And so suddenly I was not getting my phone calls anymore. Let's see. I think the thumbnail's a woman on it. We just added the butler. Okay, judge is coming in now.
All right. So we're here, State versus Tucker. Everybody's here. I just want to say something, and then we'll hear from everybody. I'm very concerned about the fact that we don't have any more defense witnesses despite the representations that we would. I'm not doing half days. I'm not doing third days. You either have your case and your evidence together, sir, or we're going to move on with this trial to the next phase, because it's completely unacceptable what the fact that Friday we've got only the problematic Zoom on Paul at Belmont. Today we have nobody else.
Your Honor.
It's not going to happen that way anymore.
Your Honor, can I please speak for a second?
Yes, sir. You did not offer one explanation
I'm
legitimate as to why your supposed witnesses weren't here.
I will literally, if you'll give me just a second, I can go ahead and explain.
Yes, sir.
Okay. First off, we were given 4 weeks when I had attorneys, Your Honor.
That was an outer limit. It wasn't not so we could take
I'm not planning on it. And I'm not planning on it. I just cut my witness list down so that we could make sure that it's going to be timely, Your Honor. But I have I have no way of knowing how fast transport's going to bring Todd O'Quinn from the prison.
I can tell you they're not going to be bringing him any time during the course of this trial. Unless you've got a order to transport ahead of time, which I haven't been presented with one.
Well, and the thing is, okay, well, that's Your Honor. That's why I also wanted to defer to the court's opinion on this, because, okay, if I can get them via Zoom, that negates that. But I mean, Zoom was problematic, I admit, right? So I didn't think Your Honor would want to go for another Zoom hearing. But at the same time, he is an important witness in this case.
Well, sir, whatever provisions you've made, that's fine. And if you haven't made proper provisions ahead of time, well, then it's on you. So in any event, Your Honor, I really not interested in hearing more right now, sir. I'm not interested in hearing it. I'm telling you that 2 days in a row, we've had trial time, we've had representations, you'd have people here, and you didn't. So, Mr. Mansfield, what did the state want to bring up? Because
Judge, the defendant has advised us that he plans on calling Seth LeVay. Seth LeVay was supposed to be here today. He's not here. He has proffered to us that his purpose in calling Seth LeVay is to authenticate the motion to suppress that the defendant believes will then be admissible in front of this jury. I submit to this court that it doesn't work that way. That written motion is hearsay. Even if Seth LeVay takes a stand and says, yes, I wrote this at the request of my client, it is hearsay. Anything contained with it is hearsay and makes it inadmissible. There is no sworn statements of Travis Johnson in that motion. Not to mention, anything that Seth LeVay gathered from his client is privileged communication. And again, Seth LeVay is not at liberty to discuss or to publish that. So I believe that us waiting around for tomorrow for Seth LeVay to come down here is going to be a waste of time, because we are moving to strike him as a witness, because I believe that anything he'll testify to is not going to be admissible.
613, Your Honor.
Not to mention, he's no longer under subpoena. So that's the first problem. The second problem is he's mentioned this Todd O'Quinn. Your Honor's already touched on it. There's been no transport order. There's been nothing, no provisions made. Todd O'Quinn is not going to be here. The next witness, he says Tom Walker, the investigator that did the IA investigation. I've already proffered to the court that I believe that most of that's going to be inadmissible, because the IA investigator who investigated these allegations of impropriety in this investigation occurred years after this crime. Again, what I believe he's going to testify to is going to be inadmissible in this trial. His subpoena ended last Friday, so he's no longer under subpoena either. So my question to the court is, are we closing tomorrow because I need to be prepared, or is there something that's going to be presented that will be admissible? That's where we're at. The defendant indicated to us on the break that after Sepulveda in the morning, he's got Chad Sabilla coming in the afternoon. So let's say that for whatever reason, Sepulveda does come down here and we start up at 9 o'clock. And by 9:15, we're done with Sepulveda. And then what are we going to do? Wait 6 hours for Chad Sabilla to come in? These are the delays that Your Honor has come out and touched upon them, but these are the delays that the state wanted to talk to the court about. We believe this defendant is holding these proceedings hostage. This is becoming ridiculous. The defendant had plenty of time over the weekend to post and open up a new YouTube channel and post all about it.
Who did that? I want evidence of that.
So here we are today, and he's not prepared with his witnesses. Todd O'Quinn is at Martin Correctional Facility. He's not going to be here. 5 hours.
That's what it is. Your Honor, I want some evidence of what he just alleged against me.
It's just argument. It doesn't, frankly, affect me. What does affect me in terms of this case is what I consider a motion in limine regarding Seth LeVay, what I consider a motion in limine regarding Tom Walker. So we can get to that.
Your Honor.
But in any event, so what now? What did you want to say, sir?
Well, Your Honor, to be quite frank, I'm going to go ahead and file a motion to disqualify tonight. So we're going to have to consider that.
That's fine.
Motion to disqualify the judge.
That pretty much ends the conversation right here, doesn't it?
No, sir, not at all.
I mean, because look, I am doing my best to make sure my witnesses are here.
Sir.
Right, but I'll tell you what, it's not exactly easy when first off, I have to go through the clerk, which they don't have to do. But not only that, we did go over and we had overlap, Your Honor. That is the way it is. Now, I just confirmed my witnesses. Right? Now, they want to say that Tom Walker, because they're thinking I'm going to go to, see, this is the thing, they're thinking I'm going to go, to that. But no, there's been evidence that has been tampered with, and we need to figure out which ones. Tom Walker has that knowledge. That's the bottom line. I don't know which videos have been tampered with. I don't know which ones, haven't been. I don't have that list. Tom Walker does. I know a lot of them have been. Lord knows I can't use my own interview video. It's been chopped into, 60 pieces, 70 pieces?
Why isn't Tom Walker here today, as you said he would be on Friday?
Because, Your Honor, like I said, like he just said, my subpoena had run out. And like I said, I had to reissue my subpoenas. And yes, I went ahead and clarified it with everybody just now. Again, to make sure that, no, there is no further delays. Now, as far as Todd O'Quinn got in touch with me this weekend, right? Now, okay, I had trouble figuring out which facility he was in at first because they moved him. That's a problem. Then the other problem is they put him with Rory Wilson. How'd that happen?
Who knows? And it's irrelevant to what we're doing here.
Well, it's relevant if all of a sudden I don't have a witness,
So the record's clear. I checked Odyssey 5 minutes before Your Honor to defend. There have been no further subpoenas issued by the judge.
No, they're sitting right here because I just decided. I was like, okay, which ones am I going to narrow down? And I did want to talk to the court, but apparently the court doesn't want to talk to me, which is why I need to make a motion to disqualify.
Sir, I believe we're having a hearing right now. I'm just expressing my concern about your ineptitude,
Your Honor.
Sir, again, you're speaking over me.
Okay.
Your inordinate, inappropriate delay of the proceedings. If this wasn't a lawyer, it would not be tolerated. I've bent over backwards to accommodate you, but we've reached the limit. I'm not going to be sending this jury home for half days anymore. You're either ready to go or we move on to the next stage of the proceedings.
I'll have my motion ready for you tomorrow.
Sir, That is not relevant to what we're doing now or what I expect to
I know what the law
happen tomorrow.
says.
Well, okay, that's fine, sir. So do I. But like I said, that doesn't affect what we're addressing now. And as far as Seth LeVay is concerned, what is it that you expect him to testify to? Because if it's nothing more than saying, yeah, that's the motion to suppress that I filed.
Well, and he's also willing to say that, yes, his client did put say that his confessions were false. It literally says it right on the outside of the document, Your Honor, and it literally says inside the document, those are all previous inconsistencies. That's 613 all day.
Any more argument from the state? Because if that's what you're calling him for, I'm granting the motion. None of that is admissible. None of that is. Sir, I'm not going to start teaching you a law class now.
I mean,
that is a motion. Mr. LeVay cannot invade the attorney-client privilege. What he alleges in the motion is not admissible. So the fact that you don't have him here is yet another problem, which you said you would. But regardless, I'm granting the state's motion.
Your Honor, you're saying I can't take a previously inconsistent statement, put it in front of Mr. Johnson and say, did you say this?
I am saying Mr. Johnson's attorney's unsworn motion doesn't consist of a previous inconsistent statement. That's what I'm saying. Okay. And nor can you ask Mr. LeVay what his client told him. Those are all clearly inadmissible. So the motion to strike LeVay is granted. In any event,
Your Honor.
Yes.
I will go ahead and I have my list for tomorrow. I have my list for the next day. But again, if I file that motion, there is going to be no tomorrow.
Sir, you can file whatever motion you want, but your understanding of that particular motion, is what it is. I will make an appropriate ruling, and we'll go from there. But in any event.
I guess we'll see.
So in any event,
Mr. Tucker's.
What else did the state? I don't expect closings tomorrow.
Just spending.
But like I said, what I do expect is if Mr. Tucker does not have witnesses under subpoena, witness evidence ready to go, or witnesses standing by, I'm not sending this jury home anymore. We're going to proceed because that is not the way a trial is conducted. I've been more than indulgent in terms of giving him every opportunity. And so whatever you want to present or intend to present, I'd have it lined up, sir. So
that's fine, Your Honor. It's like I said, but I guess we'll see you tomorrow.
Yep. Okay. Anything else? Anything else?
Wow.
All right, so we'll be here at 9 o'clock and we'll go from there.
All right. So you didn't miss much. You didn't miss much this afternoon. Wow. Judge Carroll wouldn't even let people look at him sideways. This guy is copying an attitude and slamming papers. Welp, that was a threat. Yeah, there was... He's basically, what Mr. Tucker is saying is that he is going to file a motion to remove or dismiss the judge from the case, saying this judge is not being fair and he needs to be taken off the case. What does that do? I think it might be a do-over. It might be a do-over at this point. I just don't know if you can just switch judges midstream like this and still move forward. So that motion's coming in. Watch for that. Tucker also has said basically his understanding is that that brings the trial to a screeching halt. I'm not sure if filing the motion does or if the motion is being granted does. I'd say the second one might be the case. So now he has no AM witness. He just had him struck. The judge granted the motion to strike the witness. You can't call that attorney. He can't testify. The motion he filed is not admissible evidence. You can't put the document the attorney filed to suppress the evidence, to suppress the testimony in front of Travis and say this is is this a statement? It's not admissible for that purpose. He can't do that. It's not a previous inconsistent statement, something his attorney said. Tisha, wow, you and me both. This is crazy. This is crazy. All right, so now what? So tomorrow it's going to start off with a bang, because they're going to have possibly, well, we're possibly going to have. You guys are wanting some music. You're not just any music. You guys are wanting this music. What's his YouTube channel again? I have not found it. If you guys have found the new YouTube channel that he's accused of making, I see we've got Free Franklin Tucker with 205 subscribers. But that's older. That was an old channel. Let's see if there's any others. I'm not seeing any new videos posted. Oldest one is 8 days ago, and most of it is just an interview video footage. Interesting, he shares a Google Drive link on that defense report, DNA report, Rory Wilson interview, Todd Quinn deposition. It's got all sorts of stuff on that one. Let's see, I'm not finding this other channel. We've got Justice as a Process that's been looking at this closely. That's not his channel either. Let's see. We have our favorite Ivan on the phone here. Let's see.
Call from
Mr. Ivan.
Ivan, do you want to talk with this music in the background, or you need more silence?
Hey, whatever you need, man.
Okay. Ivan, what's happening, my friend?
What just happened here? So let me first get back to Paula, okay? Like, because I know a lot of people had questions about Paula and why she ultimately got upset. Well, let me tell you something, okay? Pardon the background noise. I'm walking, okay? So you hear street noise. But I've dealt with 100 Paulas in my life, okay? The one way to anger an addict is to cut off their source. And so the second they started bringing up her informant history and her snitch history, let me tell you what that does to an addict who is trying to play both sides of the coin. Okay?
Go ahead.
It removes her ability to be an informant. She can no longer be an informant. She's on the stand, okay? She's exposed, okay? Like, she can no longer provide to the police. But on the other hand, she can no longer score from the people she's scoring from. So you effectively have burned two bridges.
Both ends of her.
With what? Yes.
Wow.
You burned two bridges with one stone, okay? Because and I'm not trying to be disrespectful. Everybody knows I'm empathetic to addicts. But let's be clear here. When a junkie is on their last leg, they will do anything. And when I say anything, I mean anything. All right.
The addiction is so powerful.
It's the worst thing in the world.
They'll turn against family. They'll do all sorts of things, and it's terrible.
They'll sell out their dying grandmother for a quarter gram. Okay, like that happens every day in every city, everywhere. Okay, so the reason she got so indignant there is because she's realizing not only am I burnt up as an informant, because I have seen. And I know it goes against police protocol or rules or whatever. I have seen police give addicts drugs for information. It happens every day. It's not supposed to. It's against the rules. It's whatever. but it happens. Okay, she burnt that up on the sand, and not only did she burn that up on the sand, but she also gave away her source, because who else is going to sell to her now that they know she's a fucking rat? Sorry about my language.
Yeah, family show. Ivan, thanks for your thoughts. I'm going to cut it off right here. I appreciate the thoughts. You got a warning on language, so we need to go.
Hey, but
all right.
I'm just saying. At the end of the day, that's the reason she got so indignant.
Yeah.
Is because she burnt up two sources in the same statement.
Yep.
So,
all right. Thanks,
anyway.
Ivan. Catch you later, man. Bye.
Yep. Love you.
Okay. Yeah. Beep. Okay. So here, yeah, I'll have to edit that out in post. I have not been able to find the second video. I don't know if it's true. I think possibly what the prosecutor may be mentioning about Tyrone Tucker is that someone else made a video to support him that came out over the weekend and that he might have been on. That's probably more likely.
Call from Katya.
Hello, is this Tatya?
Yes. Hi.
Hey, how are you doing? This is R.A.
You said I'm good. You did say my name correctly, by the way. Just very quickly,
yes.
I was doing some investigation, and the video that the prosecutor mentioned is on the Justice is the Process YouTube channel. Franklin put that on his Facebook yesterday, about 15 hours ago. So, yeah, I was just doing some research on that.
I don't believe that's actually Franklin's channel. It's a different channel. They've done a lot of coverage of this case. But so I think the prosecutor misspoke, maybe intentionally, when he said you had time to make a new YouTube channel. That's not his channel. But yeah, thank you very much. I appreciate that. I figured that's where it turned up.
Yeah, no worries. I was just thought of saying hi as well and teach you how to say my name too.
Well, Tatya, thank you very much. What are you listed on as on YouTube? What's your username?
Katya Pickles, the one with the blonde hair.
Okay, Tatya Pickles.
On the picture.
I'll probably forget how to say that in like the next 5 seconds. But I've said it right 3 times in a row, so that's got to be worth something. Thank you, Tatya. I appreciate the call.
No worries. All right. Bye.
Ta-ta. Cheers. All right. Call from England. I should have asked what part of the UK. Let's see. What just happened? People are like, what just happened? What just happened? If you missed it, we can go back and replay, and I think we might because that was very quick. What happened after lunch here? Let's see. Hang on a second. We've got another call from England.
Call from not a spam. Fun and fun. To accept, press 1.
Fun and funky. How are you doing?
I'm good, thank you. How are you?
I'm doing phenomenal. What's on your mind today? Another two calls from the UK in the same, like, back to back. That's awesome.
Well, I've not phoned him for a while. So, unfortunately, work has got in the way, so I've not seen all of this. I've seen a lot of it, but not all of it. How is this guy connected then? Because all I've heard so far is 2 guys, what's his face, beginning with the R, and the guy that testified in his surfing pants.
So you got Rory and Travis. Yeah.
Rory and Travis, that's it, yeah.
Apparently Rory and Travis both pointed the finger at Tyrone, said he was involved. But there's no DNA that puts him on the scene. We only see 2 people going to the crime scene in the video that does exist. Rory, I mean the Tucker, he did live at the warehouse, which is where these other guys were. He hung out with the same friends. He had met Paula before. He had been in the same community and possibly may even been involved in some of the same activities or recreational activities that the others were. But there was a connection there that he was an acquaintance.
Yeah. See, I'm not keen on this guy, and I apologise if his wife is listening. But he's not sympathetic to people. But I also agree that there's really not been any evidence, and that's why I called, because I've obviously missed some. So I wanted to know why he was tied in at all.
I agree. There's the evidence that has been put forward has been one witness. That was Travis, who has turned state witness. He got a special deal. He was facing life in prison, but he got time served for flipping and saying it was Tyrone. There seems to be a lot of. I mean, I can't take that by itself, but you look at that in addition to all the ways he changed, how he testified, the way he changed what he said, how he refused to admit that he had lied previously, how hostile he was to one side, and it's just I struggle to find him credible. I really do, and that's but I agree with you. That's the only thing they have that really puts him at the scene is this Travis's testimony, and everyone else, even the victim,
just word of mouth.
Paula, who was there, who watched it, said it wasn't Tyrone. 100% sure it wasn't Tyrone. We heard that today. So.
Yeah, she wasn't particularly sympathetic to the viewers either, but I'm not going to judge her, you know. Yeah. But thank you for that, because I was getting a little bit confused with what I've seen, and it was like, well, where does this guy come in? But so thank you, R.A.
Not a problem. Thanks for the call. Appreciate it, Fun and Funky.
Cheers.
Cheers.
Bye.
Bye. All right. We have, let's see, I'm going to go back. We're going to rewatch what just happened here because it happened so quickly. And it just spun out of control. It got first of all, the judge walks in and he's been thinking about this all lunch. He probably comes back and he's got indigestion. Okay. He probably did not enjoy his lunch because he's frustrated. Now, before we listen to it, just realize that last week we had a day where the state did this exact same thing, where they said, hey, Judge, we thought this was going to go longer, and it didn't. We don't have any witnesses. And they took a break all day. That was Tyrone's fault. Today, this technically also is Tyrone's fault. But these things happen in court. These things happen. I think this particular one, a lawyer would have prevented it happening. A lawyer would have known how to schedule the attorneys or schedule the witnesses, would have known how to get the order to transport filed and submitted and processed so you could get somebody moved from jail, all that. But we'll see. So we're gonna pick up and rewatch what happened right after lunch. Here, if we give it just a minute to get caught up. But man, it gets spicy fast. This is just crazy. Let's see. I'm going to turn off the law counter. We're on the current law counter. Let's see. We're up to 75. Let's see. Right here, we're up to 75 on the law 101 counters. So we'll give it just a minute. I think the judge is about to walk in. I don't want to fast forward because then I'll miss it. But okay. E-Murph says, I'm 17 minutes behind, and this is my Friday with this trial. Spicy judge rocks. This spicy judge might be off the case if Mr. Tucker gets his way. He's going to file a motion tonight, I believe, or tomorrow morning, a motion to dismiss the judge. Motion to get him off the case. I think the judge is about ready to come on right here. Here we go. This is it. We're rewatching what happened here.
Please be seated.
Call from Misty from Frigid, North Dakota.
All right.
I'll take this one off.
We're here, State versus Tucker. Everybody's here. I just want to say something, and then we'll hear from everybody. I'm very concerned about the fact that we don't have any more defense witnesses despite the representations that we would. I'm not doing half days. I'm not doing third days. You either have your case and your evidence together, sir, or we're going to move on with this trial to the next phase, because it's completely unacceptable the fact that Friday we've got only the problematic Zoom on Paul at Belmont. Today we have nobody else.
Your Honor.
It's not going to happen that way anymore.
Your Honor, can I please speak for a second?
Yes, sir. You did not offer one explanation legitimate as to why your supposed witnesses weren't here.
I will literally, if you'll give me just a second, I can go ahead and explain.
Yes, sir.
Okay. First off, we were given 4 weeks when I had attorneys, Your Honor.
That was an outer limit. It wasn't not so we could take
I'm
lengthy
not planning on
breaks.
it, and I'm not planning on it. I just cut my witness list down so that we could make sure that it's going to be timely, Your Honor. But I have I have no way of knowing how fast transport's going to bring Todd O'Quinn from the prison.
I can tell you they're not going to be bringing him any time during the course of this trial, unless you've got a order to transport ahead of time, which I haven't been presented with one.
Well, and the thing is, okay, well, that's Your Honor. That's why I also wanted to defer to the court's opinion on this, because, okay, if I can get him via Zoom, that negates that. But I mean, Zoom was problematic, I admit, right? So I didn't think Your Honor would want to go for another Zoom hearing. But at the same time, he is an important witness in this case.
Well, sir, whatever provisions you've made, that's fine. And if you haven't made proper provisions ahead of time, well, then it's on you. So in any event,
Your Honor,
I really not interested in hearing more excuses right now, sir. I'm not interested in hearing it. I'm telling you that 2 days in a row, we've had trial time, we've had representations, you'd have people here, and you didn't. So, Mr. Mansfield, what did the state want to bring up? Because
Judge, the defendant has advised us that he plans on calling Seth LeVay. Seth LeVay was supposed to be here today. He's not here. He has proffered to us that his purpose in calling Seth LeVay is to authenticate the motion to suppress that the defendant believes will then be admissible in front of this jury. I submit to this court that it doesn't work that way. That written motion is hearsay. Even if Seth LeVay takes a stand and says, yes, I wrote this at the request of my client, it is hearsay. Anything contained with it is hearsay and makes it inadmissible. There is no sworn statements of Travis Johnson in that motion. Not to mention, anything that Seth LeVay gathered from his client is privileged communication. And again, Seth LeVay is not at liberty to discuss or to publish that. So I believe that us waiting around for tomorrow for Seth LeVay to come down here is going to be a waste of time, because we are moving to strike him as a witness, because I believe that anything he'll testify to is not going to be admissible.
613, Your Honor.
Not to mention, he's no longer under subpoena. So that's the first problem. The second problem is he's mentioned this Todd O'Quinn. Your Honor's already touched on it. There's been no transport order. There's been nothing, no provisions made. Todd O'Quinn is not going to be here. The next witness, he says Tom Walker, the investigator that did the IA investigation. I've already proffered to the court that I believe that most of that's going to be inadmissible, because the IA investigator who investigated these allegations of impropriety in this investigation occurred years after this crime. Again, what I believe he's going to testify to is going to be inadmissible in this trial. His subpoena ended last Friday, so he's no longer under subpoena either. So my question to the court is, are we closing tomorrow because I need to be prepared, or is there something that's going to be presented that will be admissible? That's where we're at. The defendant indicated to us on the break that after Seth LeVay in the morning, he's got Chad Sabilla coming in the afternoon. So let's say that for whatever reason, Seth LeVay does come down here and we start up at 9 o'clock. And by 9:15, we're done with Seth LeVay. And then what are we going to do? Wait 6 hours for Chad Sabilla to come in? These are the delays that Your Honor has come out and touched upon them, but these are the delays that the state wanted to talk to the court about. We believe this defendant is holding these proceedings hostage. This is becoming ridiculous. The defendant had plenty of time over the weekend to post and open up a new YouTube channel and post all about it.
Who did that? I want evidence of that.
So here we are today, and he's not prepared with his witnesses. Todd O'Quinn is at Martin Correctional Facility. He's not going to be here.
5 hours. That's what it is. Your Honor, I want some evidence of what he just alleged against me.
It's just argument. It doesn't, frankly, affect me. What does affect me in terms of this case is what I consider a motion in limine regarding Seth LeVay, what I consider a motion in limine regarding Tom Walker. So we can get to that.
Your Honor.
But in any event,
when the judge says what I consider a motion.
So what did you want to say, sir?
Well, Your Honor, to be quite frank, I'm going to go ahead and file a motion to disqualify tonight. So we're going to have to consider that.
We're going to talk about that in just a minute.
That's fine.
Okay.
You can.
That pretty much ends the conversation right here, doesn't it?
No, sir, not at all.
I mean, because look, I am doing my best to make sure my witnesses are here.
Sir.
Right, but I'll tell you what, it's not exactly easy when first off, I have to go through the clerk, which they don't have to do. But not only that, you know, we did go over and we had overlap, Your Honor. You know, that is the way it is. Now, I just confirmed my witnesses. Right? Now, they want to say that Tom Walker, because they're thinking I'm going to go to, see, this is the thing, they're thinking I'm going to go, you know, to that. But no, there's been evidence that has been tampered with, and we need to figure out which ones. Tom Walker has that knowledge. You know, I mean, that's the bottom line. I mean, I don't know which videos have been tampered with. I don't know which ones, you know, haven't been. I don't have that list. Tom Walker does. You know, I know a lot of them have been. I mean, Lord knows I can't use my own interview video. It's been chopped into, what, 60 pieces, 70 pieces?
Why isn't Tom Walker here today, as you said he would be on Friday?
Because, Your Honor, like I said, like he just said, my subpoena had run out. Like I said, I had to reissue my subpoenas. And yes, I went ahead and clarified it with everybody just now. Again, to make sure that, no, there is no further delays. Now, as far as Todd O'Quinn got in touch with me this weekend, right? Now, okay, you know, I had trouble figuring out which facility he was in at first because they moved him. That's a problem. Then the other problem is they put him with Rory Wilson. How'd that happen?
Who knows? And
you know,
it's irrelevant to what we're doing here.
It's relevant if all of a sudden I don't have a witness.
Is Rory going to kill him? What is he saying there? Ernest.
No,
jury member, 12 months. Thank you so much. 12 jars of pickles there. Thank you. Oh, let's see. 1, 2, 3, 4, 5, 6, 7, 8.
But apparently the court doesn't want to talk to me, which is why I need to make a motion to disqualify.
Sir,
thank you, my
I believe
friend.
we're having a hearing right now. I'm just expressing my concern about your ineptitude,
Your Honor.
Sir, again, you're speaking over me.
Okay.
Your inordinate, inappropriate delay of the proceedings. If this wasn't a lawyer, it would not be tolerated. I've bent over backwards to accommodate you, but we've reached the limit. I'm not going to be sending this jury home for half days anymore. You're either ready to go or we move on to the next stage of the proceedings.
I'll have my motion ready for you tomorrow.
Sir, that is not relevant to what we're doing now or what I expect to
I know what the law says.
Well, okay, that's fine, sir. So do I. But like I said, that doesn't affect what we're addressing now. And as far as Seth LeVay is concerned, what is it that you expect him to testify to? Because if it's nothing more than saying, yeah, that's the motion to suppress that I filed.
Well, and he's also willing to say that, yes, his client did put say that his confessions were false. It literally says it right on the outside of the document, Your Honor, and it literally says inside the document, those are all previous inconsistencies. That's 613 all day.
Any more argument from the state? Because if that's what you're calling him for, I'm granting the motion. None of that is admissible. None of that is. Sir, I'm not going to start teaching you a law class now. I mean, that is a motion. Mr. LeVay cannot invade the attorney-client privilege. What he alleges in the motion is not admissible. So the fact that you don't have him here is yet another problem, which you said you would. But regardless, I'm granting the state's motion.
Your Honor, you're saying I can't take a previously inconsistent statement, put it in front of Mr. Johnson and say, did you say this?
I am saying Mr. Johnson's attorney's unsworn motion doesn't consist of a previous inconsistent statement. That's what I'm saying. Okay. And nor can you ask Mr. LeVay what his client told him. Those are all clearly inadmissible. So the motion to strike LeVay is granted. In any event,
Your Honor.
So Seth's not coming.
Yes.
I will go ahead and I have my list for tomorrow. I have my list for the next day. But again, if I file that motion, there is going to be no tomorrow.
Sir, you can file whatever motion you want, but your understanding of that particular motion, is what it is. I will make an appropriate ruling, and we'll go from there. But in any event,
I guess we'll see.
So in any event,
slams the papers down.
What else did the state? I don't expect closings tomorrow.
Yeah, there won't be closings.
Like I said, what I do expect is if Mr. Tucker does not have witnesses under subpoena, witness evidence ready to go, or witnesses standing by, I'm not sending this jury home anymore. We're going to proceed because that is not the way a trial is conducted. I've been more than indulgent in terms of giving him every opportunity. And so whatever you want to present or intend to present, I'd have it lined up, sir. So,
that's fine, Your Honor. It's like I said, but I guess we'll see you tomorrow.
Yep. Okay. Anything else? Anything else?
Nothing else from the state, Judge.
All right. So we'll be here at 9 o'clock, and we'll go from there.
Okay. So that was rewatching. That's why we didn't have the counter up, because we'd already counted once. Let me talk to you a little bit about that motion to disqualify. The motion to disqualify goes like this. There are 3 steps, very simply, that the Florida courts say that the judge, this applies to a judge when there's a single judge acting on the case, as we have here, when the judge is served with a motion to disqualify. And they are these: stop, drop, and rule. It's like when you light on, you accidentally catch yourself on fire. You're supposed to stop, drop, and roll. This is stop, drop, and rule. The first step is to stop. Stop everything you are doing in the case when you're served with the motion, and do not enter any new rulings on other issues. Drop everything and review motion for procedural and legal sufficiency within 4 corners of document. That means, check to make sure it's properly done. And then rule. Rule is to prepare a simple written order granting or denying the motion no later than 30 days of service. So within 30 days of when you've been served this. So the judge has to stop. He can't just take it and say, no, I throw it out. He has to make a written ruling. Okay, so there will be a break involved in here. But now going back just a little bit, as far as the actual rules for what he has to do, this is what he needs to do. The motion has to be in writing. So Mr. Tucker has to write this down. He has to allege specifically the facts and the reasons upon which the movement relies as the grounds for disqualification. Basically list all your grievances regarding this, the facts as to why you think he should be disqualified, and identify the precise date when the facts constituting the grounds for the motion were discovered by the party and the party's counsel, whichever is earlier. These little things are details. They have to be in there. If they're not in there, when the judge checks to make sure the document, all 4 corners, it's all fair and square, if it's not there, it can be dismissed. It has to be sworn to or affirmed by the party by signing the motion or by attaching a separate affidavit. He has to include the dates of all previously granted motions to disqualify filed under this rule in the case, and the dates of the orders granting those motions. I don't think there were any other ones. It has to include a separate certification by the attorney for the party, if any, that the motion and the client's statements are made in good faith. So in this case where he is his own client, I'm not sure if that's required, but it needs to be, that should be in there, that this is made in good faith, meaning it's not just a flagrant waste of the court's time. We're just trying to stall here. It has to include a separate certification by the attorney for the party, if any, that the motion of the clients that was made in good faith. Then service. In addition to filing with the court clerk, the movement shall promptly serve a copy of the motion on the subject judge as well. So it has to be served to the judge, not just filed with the clerk. And then you've got grounds. The grounds to do this. A motion to disqualify shall set forth all specific and material facts upon which a judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. The party reasonably fears that he or she will not receive a fair trial or hearing because of specifically described prejudice or bias of the judge. And there's a list of what this can be, right? There's a list of what reasons there are. Like the judge's wife is, involved in this. The judge is acting as a lawyer in the proceeding. He has more than a minimal interest that could be substantially affected by the proceeding. He's going to be a material witness or expert in the proceeding. There are all these reasons. There's also the judge served as a lawyer, was a lower court judge in the matter in controversy. That's nothing to apply. But this fourth one, part 4, the judge has prior personal knowledge or bias regarding disputed evidentiary facts concerning the proceeding. I believe that's the one that Tucker is going to say, you have prior personal knowledge, because this judge has been involved for a long time on this case. And all this, I mean, his name's all over it. His name is all over it. He was there with these depots. This is not new to him, and he's saying that he has prior personal knowledge or bias regarding disputed evidentiary facts concerning the proceeding. That's going to be where he's going to be there. Now, the judge has to rule to disqualify himself. No, it sounds funny, but he has to rule this. And if it doesn't, then it can become an appellate issue if he doesn't disqualify himself. So yeah, this is happening. I will tell you this. This document, this legal document, is one of the more complicated motions that can be filed in a court case like this. A motion in limine is much simpler, but here you've got all these parts and pieces, and every I has to be dotted, every T has to be crossed. It has to be proper. The judge gets to review it to make sure it's proper, and if it's not proper, it can be dismissed on the face value without, on paper. Just throw it out without argument. So he has to be very careful in writing this and realize if he doesn't have an attorney, he's on his own there. Let's see. But isn't that the case in many trials that go on for a long time with the same judge? Yes, but the longer something goes with a judge, probably the more ammo you have, right? The more different scenarios that have popped up where the judge, today, something of concern is Mr. Tucker was making his argument for something, and the judge cut him off. And Mr. Tucker said, I'm not done. I've got something to say. And he said, I don't care. I don't want to hear it. Like that could be a problem because he is acting as his own attorney. So Tucker might have some grounds for this. Hey, Jules, how are you doing?
Hey, good. It looks like I missed a lot of juicy stuff because I was at the doctor's all morning.
Just a little bit. Yeah,
I got to tell you, Scott.
Yeah.
I had sympathy for this guy. In my heart of hearts, I felt that the state did not prove their case, okay? But after this replay you just showed me, I know it was not in front of the jury, but his attitude.
It's quite out there. I mean, it's quite strong.
I mean, I even know you don't speak to a judge like that. I mean, oh my God.
Can you imagine Judge Carroll in that situation? How he would have handled that?
Oh my gosh!
If Hunter had taken his papers and slammed him down on the desk mid argument with the judge,
he would have probably said, "Do you have your toothbrush with you?"
We've got accommodations for the night. Yeah.
Yeah, exactly. There's no way. Even on that one part where you said he may have a chance on getting getting this recusal. I can't even talk today.
Disqualification.
There's no way. Yeah, there's just it's. I don't think it's going to happen. I really don't. This is where at times like this you do need to have a lawyer. You do.
Oh, this entire trial. You need to have a lawyer this entire trial. I realize why he did what he did. But yeah, it's crazy. Jules, thank you very much.
It is crazy.
Great.
Well, wait, I got to tell you something really quick.
Okay, go ahead.
When I wore my hoodie.
Okay.
I wore my hoodie to the doctor's, okay?
Yeah, okay.
And as I'm finally leaving, I turn around and I'm not going to say what she said because she called me by my given name, and she was like, wait. You're not the one that was calling in on Recovery Addict. I said, do you watch him? She says, I listen to him every day, but don't tell anybody in the office. I thought that was so funny.
Oh, that's wonderful. That's awesome.
I know, right?
You got
Everybody have a
identified
great
out
afternoon.
in the wild. Thank you, Jules. Appreciate that. We'll see you.
Have a great day. Bye-bye.
Bye. Thank you, Jules. Appreciate the call. The person who's calling in, call back real quick. I'll see your number and let you in. Yeah, let's see. Who rules on the motion to disqualify? The judge rules on it. The same judge who has been, said you need to just be disqualified. He has to rule. Now, realize this is very ripe area for an appeal. Okay, if an appeal is requested and there's been a motion to disqualify, this is something that the appellate judges are going to look at closely. But Tucker has to do it right in order to have a chance here. And I just don't know. I mean, if he's just writing his motion now, I mean, he needs dates and times and screenshots and receipts and everything spelled out in detail. And he might have it. Maybe his advisory council might be able to give him a template. He can fill in the blanks and have everything right. But he needs to make every argument, when you make an appeal, you're appealing on everything, all the things you thought were wrong. Okay, this is basically what he needs to do to this point where he has all those things with timestamps and dates and reasons and everything else in this document. And he's starting it now. It'll be ready tomorrow. This is a ton of work for a legal team. And I just don't know if he's A, going to get it done and get it done properly, or B, if it will do any good. But do we know if the judge presided over Rory Wilson's trial? I thought he did. Only because I know in the deposition that we were watching this morning with Paula, he was mentioned as the judge. Is the judge going to be here, specifically by name? Yeah. Oh man. Maybe at this point the judge is like, please, just any way to get off this case. I'll go ahead and dismiss myself at this point. I think the judge wants off this trial, says Mother Beagles, sorry. Okay, here we go. Calling back. Let's see who it is.
Call from Misty.
Misty, this is Scott. How are you doing?
Hi, Scott.
Thanks for calling back.
Hey, yeah, no problem. I have a couple of things. Number one, I'm from North Dakota, and I don't know if you've heard of the static case up here. But what it was a teenage boy going to college up here, got in trouble for having Mary Jane. The cops converted him to a narc or a informant. Mm-hmm. He ended up disappearing, and they found him dead in the river. Ooh. So, with her not wanting to express the informant part, could very much be that it's a safety concern. I mean, it could lead to something that could be disastrous.
Yeah,
very much so. Very much so. The other thing I was going to say is, really, I think Tucker could absolutely just stop his case right here. And if they have any kind of common sense jury, I do not believe they would ever convict him.
I agree. I think he's winning right now. I think he's winning.
Yeah. I really think he could just, after the Paula thing, he could literally just sit down and shut up. And I think this would be an over and done case.
Yeah, as long as the jury was able to hear that, and that was. I mean, I did a lot of work on this end to make it more audible. But if the jury heard what she testified to, you've got the surviving victim who can swear 100% certainty it was not him, that he was not there.
It was not him.
Like,
correct.
Yeah.
Yep, and that's all I wanted to say. I was just, but that to me, when she said that and they kept pushing her on that, I kept thinking to myself, if that got out, if she narked on anybody and they get out, it could be a death sentence for her anyway. Yeah. And so I was really shocked that it had even come out in court, because that's something that's usually pretty protected.
Yeah, she was not happy about that. She was very upset. And granted, this is all back in 2020, but and she's since then that it has come out, and she hasn't been attacked since then that we know of. I don't think the attack at the robbery that night was because she was a narc. I mean, there was no evidence of that. But
no.
Yeah, interesting.
But I can see why she would have been very hesitant.
Yeah. I have one question before you go. What's the temperature up there in North Dakota?
Hold on. I gotta look at my phone here. Give me 1 second. I'm a looking. I gotta look at my phone. It's actually really nice. It's 25 right now, so it's really gorgeous outside.
We're almost up to freezing. So, a few more degrees and you can unplug the engine block heater. So, yeah.
Right. We spent all last week like 13 below with 35 degree wind chills and stuff like that. So now it's just sweater weather.
Yeah, that is so cold. It was 19 this morning. We're already up to 50 degrees here, which is just it's a heat wave. So I was out with shorts and a t-shirt petting the cat over lunch. So.
Yeah, 25 here is a heat wave in the winter. We've had a very, very nice winter.
Man.
So
keep the
not
cold
bad.
weather.
Last winter was bad.
Yeah, we don't want it. So thank you so much. Appreciate the call. We'll see you.
Yep, bye-bye.
Bye. All right. It's funny that Tucker was complaining because it was hot in the courtroom this morning. Not funny, but it's just I shouldn't say it was funny that he was complaining, but it was interesting for most of the country who just wishes it would get above freezing. That Tucker's like, well, this heat wave is driving me nuts. I'm not used to the heat. 71 in the courtroom and humid, but good times. All right. You know it's been cold when you say it's a nice and it's 25, says Karen. All right, so we are done with the Treetop murder trial for today. Obviously, tomorrow's going to come around again, and it's probably going to be spicy. We're going to have I'm predicting more witness issues where things are not as the judge might like them to be. Sorry, I have to jump to this every once in a while. Let's see, we're over $208,602,000 now, and the J Hatch counter, it's flying. Fun and funky. I didn't ask your temperature, so I'll tell you. It's 8 degrees Celsius in Bishop Stratford. 8 degrees, that puts it's like 42, 43, 45 Fahrenheit for those that need the conversion. I don't know. I know there's a formula that will help me get there, but that's close enough. It's above freezing at least. 8 degrees above freezing Celsius. Let's see. Has anyone found? Can you show the thumbnail? Let me show the latest. Give me just 1 minute to bring the latest thumbnail up because we probably need to make a couple additions on this one. Just 1 second here. Okay, the latest thumbnail is right here. Let me get my face off the screen so you guys can see it. Here's what we have. We added the butler. He's up there by the in front of the ship. We've got SVC Pharmacy, not CVS because we wouldn't want to confuse the two and get sued. I don't know if there's anything else we need to add to the list. Ivan, you're okay. I've timed you out for the day call wise. That's it. We love you. Tomorrow's a new day. The interest counter. You want the interest counter? We can't put the interest counter on here. But yeah, a hospital bed. No, we're trying to keep it evidence wise. Can we get a red-faced judge? Thinking that nothing's resonating yet. I actually got a text from Cachette, one of our great mods, who helps us out, saying, "Here's a list of let's see, list of suggestions for the thumbnail: train wreck, a flea circus, not allowed emoji, denied, a smoking gavel, angry emoji, and a circus." Where could we put the circus? How do we get that to work? Let's go back here and oops, not that one. Need to pull up. We're going to start court hopping in just a minute, guys. Sorry, but this is important. We've got to get some things done. Okay, we're going to go here. What do we have by way of circus? Circus images. Some tents or something off in the distance. If I could layer it back. Let's send it back a little bit and see what happens. It's a court command. What is that? Okay. Command open bracket. So we're going to do command open bracket. There we go. So the circus tents are behind the bushes. Maybe over here. Does that work? And then we'll put this up a little higher. Maybe shrink it down. We need this real estate is the problem. There we go. We've got the circus tents in back. Oh, that's not it. That's this. That's this one. I want the flag. Flag's important. I'll shrink it down this way. There we go. So we have some circus tents. That's the latest and greatest. We'll add that. We didn't add Tom Thumb. I voted against that one just because it would be a hard reference to get. I mean, a little miniature guy or just we added a thumb, but not the miniature guy. So we've got the thumb down here. If you guys see down right above the truck, we added the thumb, but that's it. It's getting very busy. Yes, long courts are going to be very crowded with this if we continue this. Let's see. Is there a key lime pie on there? There is key lime pie. It's right over here by the trailer. If you look, there's our key lime pie. I don't know why that's highlighted. I don't want that highlighted. There we go. Okay, that's how we're going to leave that one. All right, back to where we were. Anything else? Every thumbnail should have a small bingo card. Mr. Beast just tweeted, hey, if you're on Twitter, by the way, I'm going to give 10 random people that repost this and follow me $25,000 for fun. So he's giving away the money that he just made on Twitter because he made $250,000 in a week on a video he posted there. Quite interesting. So go ahead and repost that one if you want to win, I guess. Or repost it on my channel so you guys can see it. Okay, we've got another call coming in. Let's see who this is. Hello? Hello? Man, it was a scam call too. They keep hanging up. Sorry, I'm trying to do some Twitter things. Just 1 second, guys. All right. Where are we? Are we ready for court? We're ready for some, let's Let's see who is available out here in the land of court hopping. Thurston County District Court in Lacey is going live right now, I think. Let's see if they're up. Oh, did they drop? Man. District Court 4. Well, they had a jury trial a few minutes ago. What's this one? Hang on one second. It's a very patient judge. So if one of you guys gets the money from Mr. Beast, you have to tell me.
Morning, it's Thurston County District Court. Our trial calendar for Monday morning, the 22nd of January. These proceedings are being live streamed on YouTube.
Yes, they
Increased public access. Mr. Eastwood, good morning.
Morning, Your Honor.
Kale, good morning.
Good morning, Your Honor.
And I'm assuming counsel are here on the Southard matter, is that correct?
Southard, Your Honor, but yes.
This is supposed to be a jury trial, so I'm trying to see if they're going to be in jury trial today or what.
And Mr. Pez-Durka, you're here on Mr. Haugam's matter?
Yes, Your Honor.
Okay, and I'm looking for a plea form. I don't see it.
Your Honor, the agreement that I reached with Mr. Thompson is to amend the driving while suspended charge to no ball infraction. And then with regard to the pending FTC, the agreement is to stipulate to the motion to revoke and then close the case.
What?
Okay, thank you.
No jury trial.
And Mr. Eastwood, that's the state's position?
Yes, Your Honor.
They're lowering the charge and letting him off.
And the citation on the infraction?
PNW had a case. He won it. It was not televised, to my knowledge. So he's 2 for 2 now.
Just a moment, Your Honor.
Okay. Mr. Pez-Durka, do you know the citation?
Looking up right now, I apologize.
Yes, accountability and transparency is why we watch court. Entertainment is a side benefit.
I apologize, Your Honor. Can the court repeat?
No valid license with ID.
Is Judge Boyd, is she still in her jury trial yet, right now?
It'll be 46.20.1015.
Thank you. And grant the state's motion to amend to the infraction of no valid operator's license with identification, interfinding committed. And was there an agreed forfeiture, Mr. Pez-Durka?
No, Your Honor. All right, and I apologize. Are you referring to the FTC matter or his license?
Typically on a motion to amend to an infraction, there's an agreed fine amount.
Oh, sorry, it's Monday. Yes, we are stipulating, Your Honor.
And what is that amount? Does anybody have a number for me? If not, I'll impose $150 as the fine on the matter.
So,
Mr. Halgam, you understand what we're doing today?
Your Honor, I apologize. The statute, I believe, mandates a 250.
Okay, thank you.
$250 fine.
All right, I'll impose a $250 fine on the infraction, and we'll note the violation on the hit and run charge, and we'll close that matter out.
No jury trial.
Actually, let me check.
Okay, so we're gonna bail. They're dismissing that. I'm looking at Judge Boyd's week last week, and she had a jury trial that started a week ago. And it's got 5 days, but they're partial days. She handles the docket. She handles the docket some days and trial some days. And I realize she's set up closing arguments. Looks like they streamed about an hour ago. Those were today. What was the case? What was the case of the Judge Boyd? I can see the case, the style of the case. I mean, it looks like this is State versus DUENAS. What was the case about? We can rewatch Judge Boyd's trial. We might have another one to jump to, especially with Crumbly starting tomorrow. It was an aggravated ag assault. Domestic violence. Man. I'd rather skip that. So is ag assault domestic violence shooting? Are all these, this is all the same case? It's all the same case. Jury's deliberating right now. Yeah. Okay, let's see if we have another. Protection orders. More protection order stuff. That was 3. What was in 2? Thurston County District Court in Lacey. Can't see what this was. So Thurston had a little bit of action, not a ton. Saying Wolf is live. Let's see where Wolf is. See what he's doing right now. Nope. He's not live anymore. So I'm trying to find one we can jump to. We might have Judge Wolf briefly. Let's jump in just to see what's happening here.
Frame. Ms. Davis is unique in all of my defendants' attacks because she actually filed a response to my complaint. In her response, she averred that she did owe the taxes on it. We've appeared before the court in November. On December 5th, the court entertained her request to continue the matter to allow her more time to pay her taxes or sell her property. At both of those hearings, Ms. Davis did admit that she owed the taxes. And so we're here again today as plaintiff's attorney to ask that I be rendered a judgment against Ms. Davis and allowed to proceed with the tax sale. With respect to the Kirk Frame property, the court in December did allow her to go ahead and proceed on that one. I would note before the court that Judge Lockhart Nash stated on December 5th that she would not be inclined to not allow any more continuances after today. So we are asking for judgment against Ms. Davis for the taxes that are owed. And I did get a
taxes are not super interesting.
Master's office as to amounts that are currently due as of this morning.
So we're going to go back and join Judge Boyd, who just went live just a minute ago. Judge Boyd. Let's see. I'm not sure if they. I think she's just handling docket work here.
Mr. Bonk, are you ready to proceed?
Yes, Judge.
All right.
Mr. Bunk is connecting from his man cave.
All right, State, are you ready?
Yes, Judge.
Golf clubs in the background.
Don, are you ready?
Is that a cardboard cutout of someone in the background?
Court
Who is
is
that?
calling 2023 CR 7730, State of Texas versus Jamaria Simmons. Could I have parties announced for the record for the state?
Daniel Escobar for the State of Texas.
Defense?
Charles Bunk for Mr. Simmons.
And are you Mr. Simmons?
Yes, ma'am.
All right. Mr. Simmons is appearing by video, and so is his counsel. Any objection from the state?
No.
Any objections from you, Mr. Bonk?
No, Judge.
All right. And Mr. Simmons, Mr. Simmons, you have no objections either?
No, ma'am.
All right. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Simmons, I'm showing you what's entitled Application for Community Supervision or Deferred Adjudication. Did you review that with your attorney?
I can almost read that.
Did you understand it, and did you sign it?
Yes, ma'am, Your Honor.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, waiving the repeat offender against application.
Any objection?
No.
No, ma'am, Your Honor.
All right, Mr. Simmons, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That is a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand by entering this plea you are giving up those rights?
Yes, ma'am, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Simmons, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am, Your Honor.
Has anyone promised you anything other than the plea?
No, ma'am, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
All right, off the record for a moment. It appears that there is the word cap written here. Was that scratched out?
It's not capped.
All right.
Cap?
All right, we're back on
Like
the record.
no cap?
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. The state opposes your application for deferred adjudication. This will run concurrent with 2020 CR 2196. Did you understand that to be the plea?
Yes, ma'am, Your Honor.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State all proceeds, one in all attachments.
We have reviewed the same and have no objections.
Mr. Simmons, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments.
And review the same.
And the court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. And we will come back on March 21st at 9 a.m. And at that time, the court will make a decision on your application based upon any evidence that's presented. Do you understand?
Yes, ma'am, Your Honor.
All right. Defense, is there a request for a TAP evaluation or no?
Yes, Judge.
All right. Probation, it's going to be a PSI and TAP. All right. Is there anything else from either side?
Nothing from the defense, Judge.
All right. And off the record, Mr. Simmons, my understanding, you've already had a chance to speak with probation. Is that correct?
Yes, ma'am, Your Honor.
All right. Then you are excused. Thank you, Mr. Bach.
Thank you, Judge.
Okay.
Procedural stuff. He'll be back later. It looks like a Maytag man. The cardboard in the background was like the little Maytag man. There's a big box of Goldfish crackers in the background. It was like a what is it called? I Spy. It was like an I Spy game. I love people with noisy office backgrounds. My name is not Simmons, Funky. It was just poor placement on my part. Beep, 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 back door. The Colgan man. Yes,
All
the
right.
Colgan man.
Parties on Jairus Logan. Oh, could I have a file stamp, please? That's okay.
It was a cutout of a PGA guy. It looked like a golf dude. It was right there next to his golf clubs.
Court is calling 2023 CR 7298, State of Texas versus Jairus Logan. Could I have the parties announced for the record for the state?
It was
John Robertson for Mr. Logan.
And are you Mr.
Phil
Logan?
Mickelson.
Yes.
How do you pronounce your first name?
Jairus.
Jairus. Yes.
The purse is smiling at us. It's always nice to find emojis out in nature, in the wild, and there's one in that purse for sure.
All right, counsel. Have you received all the discovery? Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Logan, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it at all the appropriate places?
Yes, ma'am.
All right, off the record. This is written in here as...
Was it the wrong paperwork, Judge? Because
no, it's written in here as et cetera, a third. I don't think that or third is supposed to be in there. Am I wrong?
Yeah, I don't think you are, Judge.
Okay. Oh, that's okay.
Yeah, that's an option that should be.
And Judge, I think the issue is because the paperwork was done ahead of time.
No problem.
Somebody put that in, so we may need to review this part.
I think the judge got a haircut.
If you all want to just scratch that out.
It looks a little fresh and new today. If you guys missed this morning, oh my goodness. Right after lunch was spicy as well. It was incredible. So, hey girl, what's up? You're leaving? Where are you guys going? Oh, you're doing all the things? Okay. See you and get back. Love you. Bye, Mrs. R.A. You guys also missed on lunchtime.
Right,
Brandy hit 15,000 subscribers. And
no,
it was
it's still
emotional
a
as
third
could be
degree.
expected.
Okay.
Just making sure, Judge.
Oh, no problem.
So yes, today in the Treehouse murder trial, incredibly spicy. I would recommend you go back and watch it. The testimony from Paula, especially on cross-examination, got heated, got very emotional. Was quite intense, and then the exchange between the judge, when the judge found out, well, after lunch, after the judge knew that there was going to be no witnesses for the rest of the day, and he sort of calls out Mr. Tucker on that. That got very heated. Mr. Tucker announced that he was going to be filing a motion to disqualify the judge, and he's like, and that just ties your hands because you can't do anything moving forward. And the judge is like, well, you have your understanding of the law, and I have mine, and we're going to see what happens. You just bring your motion.
All right, we're back on the record.
Tomorrow's going to be spicy.
All right, Mr. Logan, again, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of cruelty to non-livestock? That's a third-degree felony.
What?
The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes.
If you have a plea bargain with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Off the record. Immigration interpreter needs to be called down. All right, back on the record. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Cow tipping is livestock.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Logan, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication, and there's to be no pet ownership. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
Yeah.
I still keep looking this way. Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation and 150 hours community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer states Exhibit 1 and all attachment.
No objection.
Showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Off the record, state, there's a question back from the jury.
I haven't had
confer on that.
a George Carlin,
right.
one of the 7 dirty
We're
words
back on the record.
moment. And so he's got a
Court will find that defendant
24-hour
has
timeout
knowingly
on
and
calling in.
voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
They're going to ask for pictures and things, and we're going to get them.
Today?
No, when they come.
They just want my money.
Yeah. All right, sorry. Trying to line up an appraisal. We're trying to find an appraisal for how much the garage was worth before we fixed it up. And apparently you can do that, but you have to pay $750 for somebody to retroactively tell you how much your building's worth. Yay. Just more money. I'm not sure if it's dog fighting. This is a animal cruelty, non-livestock. It's not that you can be cruel to livestock, but generally livestock has a different rule. For instance, you can use cattle prods on cows. You cannot use a cattle prod on a dog. The rules are different that way, with how you can treat livestock and how you can treat pets. So this particular charge is against non-livestock, which would be pets. And we have a $1,500 fine, and he's sentenced with no pet ownership. We might find a little bit more out about this. Don't get me started. Is it a Walter White garage? No, it is not.
All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right. Anything you wish to say on behalf of your client?
Your Honor, we're asking the court to follow the agreement. Jairus has never been in any trouble. This is his first experience in the criminal justice field. He deals with depression and anxiety and had some external things going on with one of his mothers, one of his children. He has a 1-year-old and a 3-year-old. And then the dog, as indicated in there, the dog defecated, and he just, in the way he described it, he just blacked out. He immediately realized what he did was wrong. He went down, picked up the dog, and actually walked the dog to Animal Care Services, which was near where he lived, to get the dog treated, and voluntarily gave up custody of the dog so it could be adopted out. It's my understanding the dog recovered fine and was adopted by a good home. So we'd ask the court to give him a chance. He's experienced homelessness because of this, been having a hard time getting housing. He's been living in his car the last couple of months. He may want to see if he could transfer his probation back to Virginia while he's on deferred if he can't find housing. So we'd bring that up down the road if it's necessary. But that's the court to give him a chance. He wants to make things right and get on with his life.
All right. So what is keeping you here in Bexar County?
My son.
Right. So the depression issue, what are you doing about that?
I'm just doing the best I can. I'm staying in my car and working. Just doing what I gotta do, pay his child support and all that.
So what do you do for a living?
I'm a window cleaner.
I'm sorry?
Window cleaner.
Okay. All right. Any drug issues?
No.
And what is the court cost in this situation?
Yes, ma'am. I should have it right.
It sounds like he was cruel to the dog after the dog had an accident indoors.
$375, Judge.
All right. So the court cost for this case is $375. Would you be able to pay that? Here's the thing. I always tell people, don't just say yes because you think it's what I want to hear, because you will have to pay it if you say you can pay it. If you are able to pay it through installments, you can pay it through installments. How much money are you making a week?
$10.
I'm sorry?
Only $10 an hour.
$10 an hour. So how many hours do you work a day?
Depends on the brother. So like 4 or 5.
4 to 5 hours.
So $500 a week.
I get my SSI.
Okay, you're applying for SSI?
I'm on SSI.
You're on SSI? All right.
So he gets $500 a week.
The court is waiving
from work.
Court costs based upon the new guidelines and the new rules. He won't be able to pay it. And that's a new law that has just been given to us by the legislature. So we'll waive court costs. There's to be regular reporting.
Parenting classes.
By Zoom or in person. And what do you receive SSI for?
My disability.
And what is your disability?
Bipolarness, anxiety.
Okay. You're going to have to provide them proof of SSI within 30 days, okay? And if you are working...
Sharon, thanks for your help today. Take a rest. Thank you.
There's to be no work as a home health care provider with minors or with animals. We're going to have to do a MIC evaluation. Are you seeing a therapist? All right, do a referral to Center for Healthcare Services. Are you on any type of medications? All right, you need to say yes or no because she did say okay. So MIC evaluation or referral to Center for Healthcare Services. 2 years deferred adjudication. Field visits. 1 time per month. And that's until he's receiving mental health treatment. And anger management and regular UAs. Probation, is there anything else?
No, Your Honor.
Judge, did you probate the fine?
Yes, I did. All right, is there anything else you need from the court?
Judge, I didn't hear a fine.
Oh, it's $1,500, but it's probated.
Did you say anything about the no pet ownership?
I thought I did, but if not, I wrote it down. There's to be a $1,500 fine, probated. No pet ownership. Court costs will be waived based upon his indigency. Regular reporting by Zoom or in person. Proof of SSI within 30 days. If he is working, he's not to be employed as a home health care provider with minors or animals. MIC evaluation, a referral to Center for Healthcare Services, 2 years deferred adjudication, field visits 1 time per month until he receives mental health treatment, anger management, and regular UAs. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. We're off the record. You know what you did was wrong. There's no ands, ifs, or buts about it, and you're going to have to get control of your anger issues. Do you understand?
Yes,
oh, I'm sorry. Michelle, can you add parenting classes too?
Bingo. Parenting classes.
And we'll
I
do
called it.
parenting classes. I didn't want to give him community service hours because he already has a lot on his plate. But we'll do the 150 hours of community service restitution. And once you complete parenting classes, that will be deemed satisfied.
Okay.
And how do you have contact with your child?
Sometimes.
When you say sometimes, what is that contact? What does that mean?
Depends on their mom.
I don't think there's any formal orders in place, Your Honor.
All right. I'm going to have to do, until you take your anger management class, I'm going to have to do no unsupervised contact with minors. Once he completes his anger management class, then I'll reconsider that, okay? Do you have any family down here?
No.
Oh, gosh.
He's got very supportive family up in Virginia, Your Honor, but they're all up there.
Do you want a transfer to Virginia? Honestly, I don't see how. I mean, it could be done because you're an adult to successfully complete probation here, but you have a lot of issues going on. And your issues are not just don't pick up any new cases, report. Your issues are you're living in your car, you have mental health issues, you're working as a window washer, and you have all these other conditions that you need to complete.
I can't get transferred.
All right.
We talked about that. Do you want to try to see if you can make it work here? Or do you want to start trying to work on a transfer now?
I guess I could transfer.
All right. So which part of Virginia would it be? What county?
South Boston, Virginia.
I'm sorry?
Halifax County.
Halifax County. So we'll do a transfer to Halifax.
He needs help.
County in Virginia.
And I'm not talking about
until probation tells you you've been transferred. You're still in Bexar County. Once they tell you the transfer has been accepted and complete, then you can go there, okay? All right, good luck to you.
How would I know?
They'll let you know.
Oh, probation will let you know.
Be excused, John.
Yes.
Thank you.
And if he'll remain, probation will speak to him. And could I see your case? What's your case name? Alfonso Otero, are you ready?
He does need family support.
It is.
That's Eliseo, Judge.
Yes. No, I don't have that file. I think you guys have it.
Anyone who gets angry and blacks out and hurts animals or people
Eliseo Perez Rodriguez
needs a lot of help, mental help.
That's okay.
We've got a translator here. That's why.
All right. This is a motion to revoke. Are you all ready to proceed on the motion to revoke?
No, Judge. Probation and I concur that the defendant needs to be re-examined, and I need to file a motion for that.
Re-examined for what?
Competency.
Oh, okay. All right, Ms. Ferguson, competency evaluation, what date?
I can do March 7th, Judge.
All right, so Mr. Perez Rodriguez, what is going to happen? A doctor will see you and they will evaluate you. Once that evaluation is complete, your attorney will be given notice and then we will hear your case at that time. All right, do you have any questions?
He's a quick translator.
When will I go see him?
I can't give you an exact time, but a doctor will come see you and they'll come see you at the jail in person, or either it will be by Zoom. They will ask you some questions to determine whether or not you're competent to proceed with this hearing. If they determine that you're competent, oh, not for a while. If they determine that you are competent, you'll come back to this court. If they determine that you are incompetent, they will work with you until you regain competency. All right. Thank you.
Thank you, Judge. Maybe excuse me.
Yes. All right. There's supposed to be some paperwork plea on EGU. All right. Who's the attorney for EGU? EGU. All right. Can you call Tony Hernandez?
I did.
Okay.
But I haven't seen him. And
okay.
His client was here.
Yeah, his client is still here.
He's here?
Yeah. All right. We will wait for his client.
Seriously. Must be a challenge. The bailiffs issuing orders, just working with the schedule of moving prisoners and managing prisoners and not knowing what anyone's saying. That's going to be.
Have you all read the question?
Yes, Judge.
Are you all ready to proceed?
Well, this is a jury
with an
question.
Answer for the jury?
Yes, sir.
All right, we're going to go on
the
the record.
jury's deliberating right now.
And could I have the question? Sure.
This is the domestic aggravated assault
all right,
shooting.
We're back on the record in 2023 CR 2677, State of Texas versus David Duenes. Could I have parties announced for the record for the state?
Kelly Jackson for the state.
Defense.
Raymond Martinez.
All right, the court has received the following question from the jurors. We've come to a decision about one charge. What do we do if we have a 11/12 vote on the other? I cannot agree. And it's signed by the foreperson.
The foreman doesn't agree.
The court proposes the following answer, which is you have all the law and the evidence, continue your deliberations. Is there any objections to that?
Not the state, Your Honor.
No, Your Honor, but I'm not sure if that's an I or a one.
Yeah.
One cannot agree.
You mean I cannot agree?
Might be one cannot agree.
Okay. All right. So this is a proposed supplemental charge. Members of the jury, with reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you have all the law before you. Please continue your deliberations. Any objections from the state? No. Any objections from the defense? Any objections to sending the answer back to the jurors, or would parties prefer that the jurors be brought out and the answer be read?
Send it back.
The state has no preference, Your Honor.
I don't mind sending it back, Judge.
All right, then the court will send it back. There should be a print. Oh, you may be seated.
What's the prosecutor doing with her? Like, these are not the criminals you were looking for. Swinging like a pocket watch on a chain in front of the judge. She's not scrying very well, says Julie. Bailiff goes back with the answer.
Judge, may I approach?
Yes.
Judge, I'm here on Jeremy Tapia. I understand that he was a no-show meeting. Did not give him notice to be here today, Judge. I apologize. He was not on my calendar.
Okay.
So I don't know if we just missed a notice. I didn't find one in our email settings. I don't know what happened there, but I did call him and he was on his way here. He might be here now.
All right. Jeremy Tapia.
I'll check outside, Judge, because I know he was on his way, but I just wanted you to know he's here and that was on us that we did not.
Okay.
We're not aware of the setting. Okay.
All right. Sure.
It's nice. The attorney taking one for the team, letting the client not feel the heat. And there still might be a bench warrant out for it.
Okay.
Sandy Rhodes says, I've been watching this trial alone. I've searched for Treehouse murder to see if I could find a picture. And your thumbnail came up.
File back on Tapia.
I sure wish I'd found you sooner, but I'm not here. But I'll be here tomorrow. Sandy, welcome. Great to have you here. Yes, we do have a thumbnail. I think that's something we're going to start doing. We just started with this case. We've been, Sandy, I've been following court cases for a little over a year now on YouTube. And I think we're going to start doing that with each case. We're going to build the thumbnail for the case. And I don't know, we might try to make some a little more professional than others, but it's going to be like an I Spy, not a game, but a book that sort of just documents elements that pop up in the case that help us look at the case and remember some of the facts and presentation of the witnesses that we've heard, because it will, I'm a visual learner that way. So I can look at that and remember a lot of what's happened. Whereas if you just ask me what happened in the case, I probably wouldn't recall. I will become a Canva pro. That's good. I already pay them a few dollars a month, so their software is really good. One of the best softwares I use, I would say. Canva is one of my favorite softwares to use. My least favorite that I pay the most for, StreamYard. I'm not sure. StreamYard might be looking for people to advertise for them or to partner with them. I am not that person because StreamYard does not work. I responded to some of their advertising saying, here's what I have a problem with. And they said, tell us in detail what it is. And I told them in detail what the problems were. And I've heard crickets from StreamYard. Nothing. Pamela Camel, please consider timestamping your videos. I'm Pacific time and sometimes get so behind I give up. I do day stamps on mine, like the Treehouse murder trial. Today's date is day 6, part 2, which we're still part of, even though the Treehouse murder's over. Ooh, Kasha also has the entire Adobe Creative Suite. Now who's flexing? Let's see. I'm close enough to court. Watch for Boyd if you want to cover a trial. Close enough to court. Watch for Boyd if you want to cover a trial. I'll be the notorious paintbrush. Emotional support paintbrush. That's awesome. That would be really cool. I'll tell you this, if Judge Boyd ends up handling this case with the, now I guess the whole family that's accused of murdering the couple and their unborn child in that car down in San Antonio, if she ends up taking that case, we might need you. Or if another judge does, we might need you there. I do like Bexar County for how open the court systems are for that reason. Let's see. It all started with Paint, Microsoft Paint. 6 Volt still uses it, apparently. That's that was good software back in the day. You know it was. I mean, it was no Photoshop, but it was good. I remember sitting in a computer class, a design, like I don't know what it was. It was a computer art design class, and my teacher getting up and holding up, I don't know what it was, like a 3 or 4 megapixel camera, and saying, with the advent of this quality of camera, we won't have to go any better on the resolution. This is all we need to do. We've reached the peak of technology in photography with a 4 megapixel. Now I'm sitting here with a 26 megapixel camera that I'm using for video, and yeah, and sometimes I wish I had more resolution. The day isn't over for MS Paint. It lives on in infamy. I tell you, the downside of that 6 volt bus is having to run Windows 3.1 on your computer. Let's see. My first PC was a 486. Was it an AT or an ATX? Okay, so Richard, just telling you, I can go blow for blow with you. Back in the day, the difference between an AT and ATX platform was most notable in the power switch, and how it turned on, if it was a hard switch or a soft switch. Which camera do you use, Zimmy? I think it's a 28 megapixel. I'm using a Sony A6600, maybe 24. ICQ. Oh man, that was the day. ICQ was wild. Do you remember like LimeWire? I mean, I'm not saying I ever used it to download software like songs or computer games, but do you guys remember LimeWire? Showing age now. I have an Earthlink email address. I should have, the Brown Barn, I should have a collection of AOL online metal disc cases, advertising cases. Napster, baby. I never did Napster, but LimeWire, I never did Kazaa. Was never into AOL either. Thief, says Jamie. Back then, the laws were different. I'm telling you, the laws were different. LimeWire was easy to use. It was very simple to use. And a side gig, burning CDs in my garage in college. Man, my kid's personal Uber driver, I bought a copy of Final Cut off eBay. A new sealed in the box, factory sealed version of Final Cut on eBay. And I'm like, there's no way this guy's selling this for $25 with like $10 shipping. And sure enough, he did. And I'm like, I got to steal, because that was like expensive software. And it arrived in a stack of rubber banded DVDs stuck together with a paper with a passcode written on it. I'm like, oh my goodness. Oh, that was bad. I use Gmail and Yahoo. I have accounts on both platforms. It's easy. When I chose where to get my email, I just asked Jeeves. I said, "Hey Jeeves, where should I get free email?" MySpace, never did MySpace either. Petrified, you wouldn't download a car. I absolutely would. Nowadays, you can download and 3D print one. So. AOL chat rooms, the good old days. Oh man, chat rooms were the Wild West back in the day. My band was huge on MySpace, says Ivan. Unfortunately, you're on a 24-hour timeout, Ivan, so we can't hear your story today. We won't be able to take your call. because you said one of the 7 dirty words. Still have an AOL email. AOL is great. It's just the internet with training wheels. John Davenport said, loved LimeWire. Started with the Commodore 64 with a 33.6 KPS modem. I remember 2400 baud modem. I think there was a 1200, 2400. And then we didn't do anything until we jumped all the way up to 58, which was. But yeah, I've been on the phone playing a text-based game over the modem on a bulletin board server, and I think it was called Legend of the Red Dragon or something like that. And it's a text-based game, and I'm playing that, and then my mom picks up the phone, which interrupts the signal because the static and the communication, like fax machine stuff, breaks. And I'm like, Mom, hang up the phone, I'm on the modem. Yeah. 14.4 for you. That's screaming. I started on 1200. Yeah, half of you guys are like, what are you guys talking about? We're talking about old computer hardware. Old computer hardware. We got... growing up, we didn't have an Apple IIe. The Apple IIe was the high end. We got the knockoff, the Franklin, which ran on Apple software, and that was fun. We had the Olympic Games on the 5 1/4 inch floppy, and you'd take the floppy, stick it in the disk drive, close it, lock it down, and close it, and try type run to run the software, and you'd run the program. Then you'd go and you make a sandwich as it's loading. And you'd come back and you have to swap disks and load the next one. It was great stuff. You've Got Mail. It's a good movie. 300 baud acoustic link modem, where you take the phone and lock it in the cradle. Is that the one? Windows 95. That's cutting edge compared to what we're talking about here. Parents had a video electronics store, one of the first in our area. What we're watching here with Judge Boyd, there's a court case that's in jury watch, verdict watch right now. We did not follow the court case. It was a ag assault. Oh my goodness, when someone pick up the phone you were downloading, like 10 minutes into the song download, and someone picks up the phone, you have to start over. For those that did that and downloaded a song, first of all, it was probably in WAV format, which is not very compressed. But nowadays with MP3 format, and you can download an entire song almost as fast as you can click. Technology has come a long way. This trial is about, I believe it's a domestic aggravated assault, possibly involving a firearm. Lived in Yahoo chat rooms back in the day. Man, I almost found my way into the dark web through Yahoo chat rooms. There's some crazy stuff out there. All my school games were floppy disk. Malina's Law. I got an Apple computer as soon as they came out. I had one in law school in 1989. I mean, do you know what it would be worth now if you still had it in working condition? They weren't Apple, they were Macintosh. Yeah, it was like an Apple IIe though, right? Now, I've used the Macintosh, the little all-in-one, little handle on top, the square ones. That's my first time playing Tetris was on a Macintosh. What happened to the Treehouse case? Oh, Donna. Oh, my goodness, Donna. You've missed this morning and you missed this afternoon. This morning we had Paula testimony via deposition, and it got very spicy on cross. Very, very spicy. Then after the lunch break, we came back and we had very spicy Judge and Mr. Tucker argument. I'll say argument back and forth. And lots of threats. And basically the judge is saying, you know, you have one more break like this with no witnesses available for the jury to hear, and we're just going to call the end of the case, and we're going to go straight to closings. And Mr. Tucker says that's fine because tomorrow I'm filing a motion to disqualify you as judge, and that's going to put an end to this anyway. So we will we'll see. I don't think the judge is going to say, "Yep, you're right. You caught me. I'm disqualified." It's not going to happen. Ooh, Oregon Trail, best game ever, John. They still on Apple TV, like on my my Apple TV, you can download Oregon Trail. It's a little different, but it still has some of that same feel. But you can't go out and like shoot 500 buffalo while looking for food like you could before. Yep, there's an iOS Oregon Trail, and you can die from dysentery too. See, somebody is on the phone. Hello, this is RA. Who am I speaking with?
Oh, I subverted you.
Did you see what just happened there? Did you see what just happened there? I've dropped the volume here. No, I actually have an unstable network and the call is dropping. So, you guys, we're gonna have a vote. I've got the volume down. Ivan can't hear me. Ivan can't hear me. You can't hear him. We're gonna vote, and I'm gonna put this to you guys. We're gonna start a poll. Should I allow Ivan to call in today? And just bear in mind, the poll is up. We're going to let Ivan, you guys vote. Ivan said a naughty word today, and I had to cut him off. So the poll is up. Should I allow Ivan to call in today? We're going to go for about a minute, and then whatever the final the final word is with an egg timer. Okay. I think that's about long enough. We've got quite a few votes in already. Looks like we've had about 206 votes. It looks like the trend is already there. The trend is there, 226. All right. We're going to go ahead and bring this to a close with 226 votes. They said yes. Ivan, can you hear me?
Yes, I'm pro se. Okay.
You called in on a different phone.
Yeah, I used the text now number. I cheated. Okay.
Yeah, you're going to be really good. Otherwise, it's no.
What in the heck is this woman wearing? That's the only reason I called. Okay, like
curtains.
Is she wearing my
curtains?
Like, if she's wearing my grandmother's curtains from 1984, like, is that why? Like,
well, I'll tell you this.
What's happening?
She's rocking it. She's quite confident in it, and it looks warm, which for the judge's courtroom sometimes is very cold down there. It's a shawl. It's a scarf. So I can't.
Oh,
I can't
she's shaking
complain.
her head.
I'll tell you this: if it's crazy but it works, it's not crazy, right? And so I mean, she might be wrapped in the rug that was out in the hallway. I don't know, but she's rocking.
Okay, my real reason. I apologize for the curse word. I got excited. I got carried away. You know, I don't like to do that. Like, it's not in my character. Well, it is in my character. I shouldn't lie. Like, but it's not in my normal behavior on the channel. Okay.
Yeah.
Like, it's totally a part of my character,
Appreciate
but not
that.
on this channel.
Yeah.
But like, where do we go from here? Like, where do we go from here with Tucker? Like,
well,
what's the next?
Once he files that motion, I mean, he was right about one thing. When he files that motion to disqualify, it puts a stop to the case. It drop everything. That's Florida law. Okay, drop everything, and you have to address this. You can't address any other motion. You can't make any other rulings, and you have to respond in writing to this motion. So it, depending on how fast the judge writes and how fast he's able to.
But does he know that? Like, does Tucker know that? Like,
Oh, yeah.
does he know? Like,
oh
the,
yeah,
like,
he said he said
okay.
I know the law. I know the law. You know, I say I'm going to do this, and it's
yeah.
I think
he knows the law like I know women. Okay, yeah, like
it's a mystery. It's just no one knows.
Yeah.
It's a mystery.
Yeah. Okay.
But no, he is right about the process, at least how it starts. But it can end. I mean, this could be over. His whole motion to disqualify could be over in 30 minutes. And so if he's thinking that will get, the case dismissed for the day, or maybe permanently, it could, but the judge would have to side with him. And for that to work, he's going to have to cite some good reasoning that the judge looks at, because the judge knows that this will be before an appellate court. Okay, this motion, if you're willing to file a motion to disqualify the judge, you're going to appeal any ruling against you.
Like, to go against the judge, like you're going all out. Like, this is like heavyweight fight. Like drop the gloves. Like, let's go in the street. Like to take on the judge. Like he's got. Let me say this in a respectful way that does not violate the terms of service. He has.
I needed a delay button just for Ivan. Yeah.
He has cojones.
It takes something to stand up to the judge the judge is like the king of the courtroom, right? If there was anyone wearing a crown in the courtroom, it's the judge. That's his room, and a lot of what he says goes. But when you stand up and you're like, hey, I'm basically calling you out, okay? And
man, like, you can't go back from that. Like, there's no going back from that. So so he has to hope he wins this, because if you lose this is like challenging the end boss, right? This is like going against the lieutenant.
It's like
saying,
spitting on the end boss before the end boss fight, and then you're not going to win.
Right.
Okay, odds are, if you're not going to win this, you're losing everything else going forward as well.
This is like slapping Walter White across the face and then having no backup plan. Okay, like you can't do that. Like,
I love the Breaking Bad reference, by the way.
Yeah, right. Like, you can't just go in there with no backup plan. Like, and he has no backup plan because he's him. Like, my God, like, only if he had a lawyer. Like, if he had a first-year law student, he would have beat this case a week ago. Like, this is what Dave Chappelle called keeping it real gone wrong. Okay, This is keeping it real gone wrong. He wants to keep it real, defend himself. It's gone totally wrong, and he's going to lose. And he could have taken time served with his 2 years, but no, he had his sugar mama post bail, and so now he wants to beat the whole case. Like, man,
I cannot fault him for that.
What comes
here's what I have to say. If he is actually innocent, I'm not just saying that the state doesn't have the evidence to prove it was him, but if he is innocent, why would you go and take a guilty and have that on your record?
I don't care. I don't care.
I realize the smart thing to do might be like, hey, cut your losses and just move on. But
all right, like if they're gunning for you this hard, like, I would say, like, and there's no way to prove this, I would say the only reason they decided to prosecute this is when they realized he was going pro se. Okay, like, if he would have had like a functional lawyer or a competent attorney or a law firm representing him, they would have never even took it. They would have dropped the charges. But the second they saw he was going pro se, they're like, okay, guy, you want to do this? And here's my theory. Okay, like, I think this should be a national law. If you're a DA and you lose to a pro se,
you get fired.
Defendant,
you lose your bar
have
card.
to forfeit your bar license immediately on the spot. Like, no questions asked. Okay, like who would defend? Like,
you
know what I mean? Like,
here's another thing. It's my understanding. It's my understanding that Mr. Tucker has filed a civil suit against the county or the judge or the sheriff's office, the law enforcement. He's filed a lawsuit. He's suing them for how he was treated.
Of course.
With that already on the books, I think that also just ties their hands. They basically have to go through with this, because if they stop now, they're like, yeah, you're right, we didn't have a case, right?
I don't know if you're a baseball fan or not, but like when a team is up by like 10 runs, they'll bring in like an outfielder to pitch, okay?
Yeah.
And so when the outfielder comes in to pitch when they're down by like 10 and the game's over, and they strike out an actual hitter, that hitter shouldn't be allowed to hit for like three. Like, he gets clowned to no end. That's what this is. So, like, if you lose to a pro se defense, like, you should never be allowed to practice law again. Like, especially in a case like this. Like,
What if we did it the other way? What if you said if you go pro se and you win a case against a DA, a district attorney, you automatically get your bar license? Is that shouldn't that be fair?
Amen.
You're like grandfathered in as a lawyer.
Yeah. You switch. You switch licenses. Like you lose yours, I get yours. Guess what? Go home. Okay.
Oh man,
love you, man.
That's funny. Thanks, Ivan. Appreciate you. We'll let you call in again tomorrow.
Right,
we'll see you. Bye.
All right.
Oh man, he called me on a burner phone, guys. He called me on the burner phone to get around that. Let's see. Go to Judge Boyd's morning docket today and start at 1:10 to hear the closing arguments for this trial. Let's see. Judge Boyd. That was her morning docket.
Oh, most definitely, but I think they may be able to solve your problem beyond that.
1:10 closing arguments. You guys want to do that?
It is required that the prosecution's proof excludes all reasonable doubt
We're going back in
concerning
time
the
a little
defendant's
bit
guilt.
to see what this case is
In the
about.
event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to your jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to this case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable verdict forms are attached. State, are you prepared to proceed?
We are, Your Honor.
Okay, these are the closing arguments here.
Thank you, Your Honor.
The jury's currently deliberating. We just want to catch up on what this case was.
So members of the jury, I'm going to take about 3 to 5 minutes to basically walk through what the law is here, right? Just like Judge says, we have the burden of proof here, so I'll speak for about 3 to 5. You'll hear from defense for their 20, and then Allie will finish out with the rest of our time, okay? So let's talk about why we're here. Aggravated assault with a deadly weapon, okay? Within that, let's talk about why we're not here. We're not here to discuss motive, why certain people take certain actions, okay? You're not going to see the word motive anywhere in the packet that the judge is going to send back with you, okay? So don't worry about motive. That's not why we're here. We're also not here to litigate civil orders, who picks up when, this, that, or the other, okay? That has nothing to do with aggravated assault with a deadly weapon, okay? So within that, you're going to see here, again, the judge is going to send this back with you. You're going to see this number 6, count 1. And I really want, it's a huge packet. It's a lot of words. But the word I think you should focus on most is the word striking, okay? Striking with a weapon. On or about a certain date in Bexar County, did the defendant strike Danessa with a weapon causing bodily injury, okay? And there's a lesser included. Basically what that means is there's an assault without a weapon, but as a quick point, I would just point you to the defendant's own words in the body-worn camera. The same body-worn camera in here that you're going to be able to take with you back there, okay? Quote, I hit her in the head with the gun. Quote, I meant to push her face off me. The gun just happened to hit her, okay? That's why we're focused so much on aggravated assault with a deadly weapon, striking Danessa with said weapon. Okay, that's count 1, aggravated assault with a deadly weapon. Okay, then you're going to see kind of enumerated at the top this number 10. And again, huge packet. Let's focus on one word, shooting. Okay, shooting at Christian, right? So threatens serious bodily injury to Christian, the complainant you heard on the stand, by firing a gun. And again, just as a quick point of reference, you'll be able to look at the body-worn camera. Quote, "I grabbed my gun out and pointed it at his chest." And the occurrence of the gun shooting is really kind of incontroverted, right? You hear all kinds of accounts of it. You have 911 phone calls. We brought in the experts to talk about the firing of the gun. Okay, so that's a very high level analysis of aggravated assault with a deadly weapon, count 1, striking, count 2, shooting. Okay, and as a quick kind of high level primer again, let's talk about what the defense's theory of the case is, right? Really, 1 and 1, we're not able to make 2 there, right? So you have the quotes I just read from the body-worn camera, but there's really nothing in the body-worn camera. There's really nothing in the photos. There's really nothing in the 911 phone call. There's really nothing with the gunshot residue. There's really nothing with the kind of ballistics, shell casing testing. There's really nothing in the officer recollections to corroborate this account of what happened that night. Okay, so 1 and 1, we're unfortunately not able to make 2 with respect to that account. But when you consider the state's burden, when you consider the number of accounts that were put forth to prove, again, the very simple striking and shooting, we've got about 10 accounts on the other side that all seem to kind of corroborate each other, right? So the first account is kind of the digital evidence, right? Some photos showing some injury, some body-worn camera with the defendant's own statements that night. Kind of account number 2, if you will, is kind of the testing and the experts that came in, right? You heard all that testimony. You'll be able to consider kind of the things they brought in. All of that matches Officer Lopez's account from that night. He was actually able to talk about on the stand what he heard that night from all the individuals. And what he said that night kind of matches exactly what he said on the stand. And that matches what Danessa said that night. You kind of hear in the back of the 911 phone call. And Danessa's account that night kind of matches exactly what Danessa's account was on the stand. And that matches Christian's phone call from that night, which matches Christian's testimony on the stand. And that all kind of matches the neutral third party, the guy that was just sitting in the truck, Charles's 911 phone call that night, and Charles's testimony on the stand. So given all of that evidence, we respectfully are going to request a guilty verdict on counts 1 and 2 of aggravated assault with a deadly weapon. Thank y'all.
So that was the prosecution. I think they get to go again.
Thank you, Judge. May it please the court, counsel. Good morning, everybody.
We're just trying to catch up on the closing argument so we know what the jury's
already
deliberating.
told you that if you have questions, submit it in writing to the court. That was a very long jury charge, and it's convoluted and confusing and everything else. But she can't tell you how to interpret it. She can't tell you what does something mean. All she can tell you is if you have a specific conflict about testimony, jurors start deliberating, and one juror says, I think witness A said this. No, they said exactly the opposite. If you give her a very specific question like that, where there's a conflict, you'll get an answer. If you ask any other questions to help you decide the issue, the court's not going to help you. She's not allowed to do that. Make sure that your verdict is unanimous. That means if you don't agree with everybody else, just say so. If you get into a position where you can't reach a unanimous verdict, tell the judge that in a note. Don't just sit back there and go like, what do we do? Those kinds of questions you can send. You just can't ask the judge what things mean, what evidence means, what the effect of the law is on punishment. Can't ask any of those kinds of questions. When a person comes to defend somebody in a case, we're here trying to show to the jury why the state has not proven all the elements beyond a reasonable doubt. That doesn't necessarily mean we defend all their actions. Clearly, David could have acted in a different way that night. He exercised poor judgment in certain regards. If you feel like at some point he put his hands on her in a way that he shouldn't have, and not an aggravated assault, because I don't think they've proven those, but in a simple assault, then the language in the charge says you're allowed to find him guilty of that. Now, it's interesting, the state shows you a picture of her bruise on her arm when he grabs her to keep her from going up the stairs. Well, he's not charged with that, right? So how does that evidence help you? He's not charged with assaulting her in that first confrontation. And why is that? Part of the reason is she's the one that got physical with him first. We seem to be skipping that part. that the one who comes kicking and screaming and causing mayhem is Danessa. We know that consistently throughout the case. And I'm going to talk about that some more. So if you decide there's an assault there, I'm not going to argue that point. In the indictment, there's 3 different ways that he can be convicted of aggravated assault: pointing the gun at her, Danessa, striking her with the gun, or shooting at Christian. But what happened in this trial, on paragraph 5, the judge tells you the state abandoned the first one. What does that mean? They're telling you, never mind that pointing business. That didn't really happen. We're not really sure why we indicted him with that. We literally have no evidence of that. And so we're just going to take it back. Never mind. That should scare you to death. That an officer can investigate a case, all this manpower is addressed to the case, it goes before the grand jury, and he gets charged with something that nobody ever even said that he did. I point that out to you, and I think you should spend a lot of time focusing on that. It's because it's symptomatic of the very poor investigation that was conducted in this case, the very little thought that was put into, what happened. And we all know why that is. You get a call, a gunshot went off, they already know what they're going to do. What did the officer tell David? Stay in your room. When we finish this investigation, we're going to come take you to jail. They hadn't done the investigation yet. They hadn't even spoken to him. But they told him, we're taking you to jail. Why? Because they'd made up their mind. And it came out in the trial, oh yeah, we got a little bit ahead of ourselves. We charged him with something he never really did. The grand jury process is set up to make sure that people don't get wrongfully charged with things that they shouldn't be charged with. It didn't work in this case. It didn't even come close. Can you imagine somebody getting charged with something that nobody ever said that they did? Yeah, it happened in this case. So now we're down to only 2 different possibilities of aggravated assault with a deadly weapon. And I'm going to suggest to you,
there's my replay
you don't
icon.
need to spend a lot of time studying that very voluminous jury charge, because the state's own witnesses proved reasonable doubt. The state's own witnesses gave you all of what you needed to find reasonable doubt. Let's start with getting hit on the head with the gun. What does David tell you? And what do we know from this case? That Danessa is aggressive and puts her hands on him from the very get-go. What did the defense witnesses tell you? She's known to do that. Throughout their relationship, she never would hesitate to slap him or hit him if the thought occurred to her to do that, right? And so the hitting on the head with the gun, even though he's not intending to hit her with a gun, he just happens to do that. What the state skipped is that it was in the process of self-defense. This is a classic self-defense case. Somebody hits you, you hit them back to stop you. And why do I say that the state's witnesses prove that? Charles tells you her head goes back, consistent with Danessa's on his back, hitting him from behind, and he punches back at her. He's not trying to hit her with the gun. He's not trying to hurt her with the gun. And if that happened inadvertently, it still doesn't matter, because it falls within the 4 corners of self-defense. One of the things that's in this jury charge that is important that you should be aware of, the state has to prove beyond a reasonable doubt that self-defense does not apply. How do they do that on the issue of him hitting her with a gun? They can't. What are you supposed to do when somebody's on your back and they're slapping and hitting at you? You just let them keep doing that?
Just got a couple
You
more
let them keep doing that
filings.
because it's a girl and not a guy? No, the law is very clear. You can stop them with self-defense. The state's witnesses, through Christian saying that she fell back off of him, Charles saying her head went back when he hit her, David saying, I punched back at her. They're all consistent with each other. That striking, whether it's with the gun or without the gun, was a self-defense. There's no other way to interpret the testimony. The state might argue, well, you can't create a conflict. You can't start a fight or start a ruckus and then raise self-defense, right? So let's change the facts of the case and David did something to start an argument or a fight. And then he said, oh, but I was defending myself. No. We all know how this started. This started with Danessa insisting on getting her way, right? And I'm going to talk a little bit about whether she was intoxicated or not, because I think it plays into this issue. And she goes there, and we all know that if he doesn't stand there at the bottom of the stairs, she's going all the way to the 3rd floor, and she's banging on that door. She's going to wake everybody up because she wants to take her child, right? She could have just as easily said, oh, you're not going to let me go upstairs? Go call the police. They're going to come and they're going to let me go upstairs and get my child. She didn't do that because she'd been drinking. We know that, and I'm going to talk about that some more. And she insisted. David didn't want this fight in front of the kids. He didn't want his wife, who was a week away from delivering her child, to experience all that. He wanted to stop it there. But she wasn't going to let that happen. So no, he doesn't create this conflict. He doesn't create this fight. He doesn't create this mess. So self-defense does apply. Police officer wants to say, well,
so pistol whip
I
and
don't see any
self-defense?
injuries on him to suggest that that happened. The crime scene person told you they took over 120 pictures in this case, but only 2 pictures to the back of his head. And that's a critical issue in this case. Was he defending himself? Was he injured? And what does the officer say? Oh, no, I don't see it. Look at the pictures. There's only 2, but there's one that's very clear. He's got all kinds of redness right around his ear and behind his ear, consistent with somebody hitting or punching. We should have had at least, out of those 120 pictures, 5 or 6. Why didn't they do that? Because they'd already made up their mind. The gun went off. He's going to jail. Aggravated assault. This is a simple case. I don't even need to talk to him to make that decision. I've already decided it.
Welcome,
Why would
Broken
an
Baker
officer
and
tell him
friends.
He's going to jail before they started the investigation.
Thanks for the
because
raid.
they'd already made a decision.
Good to have the Bakers here.
I'd ask you to look at his video. His testimony on the day of the event is calm and it's consistent with what he's testified to on the trial, and it's logical, right? We all know how these child custody changes happen. People are not together anymore. They try to get along, but at some point they don't, and sometimes it gets ugly. And that's what was happening here. He had no intention of causing any harm to anybody. He wanted, as a matter of fact, he wanted it to stop. He wanted her just to leave. Let me talk about being under the influence, and why do I keep making a harp on that? Because it alters people's behaviors, right? You see in the text messages that were admitted into evidence that the communications were cordial. Hey, are you at home? No, I'm not at home. All right, I'll get with you later.
Broken Baker.
But how does
oh
it change?
My goodness. I can't wait for this
After
filing
she's been
tomorrow.
2 hours at the bar and they're running their tab, right? And he's like, no, just get him tomorrow. And she goes, no, I don't give you shit when you come late for a pick. Whoa, where did that come from?
I don't know. You said
Where did all that cordiality and cooperation go? Well, it went away because she'd consumed alcohol. She doesn't like the fact that she's being rushed. You know, she's trying to spend an evening with her boyfriend watching the football game. And so she comes over there ready for a fight. And he already knows what's coming. He's seen this movie so many times. And so he tries to stop it, right? So we have to consider Vanessa's behaviors in how we get to this position. Counsel wants to tell you we don't have to prove motive. Of course they don't have to prove motive. But motive is very important to look into what people are thinking, right? What does David want to happen that night? These kids got to be up at 6 o'clock in the morning to get on the bus. I got to go to work. We're in bed at 9 o'clock. You saw that apartment when they went in there later. It was totally dead quiet. All the kids are asleep. The exact kind of ruckus he didn't want to happen inside his apartment. It happened in the street, but it didn't happen inside the apartment. Her motivation was to get her way. That's the bottom line. And so that has a lot to do with clouding how we look at this case. So 3 ways they can prove him guilty. Number 1, they've already abandoned. Number 2, we know that if that gun hit her in the head, it was inadvertent. And even if it did, self-defense falls squarely on those facts, right? So we're left with number 3. And someone said, well, he shot the gun at him. That's easy enough. Disagree. I think number 3 is the easiest one to look at and show that there's reasonable doubt. And why is that?
Okay, so I think we've got.
You saw pictures.
We've got a good picture of this case.
They're fighting between the
from
cars.
these closing statements.
Christian says on multiple occasions he's at arm's length away from me.
We're gonna stop this
Like
for
he's
just a
like
minute.
right next to me, basically. And he shoots the gun. How does he not hit him?
Okay, so
Well, it didn't happen like that, right?
Let's go right here for just a minute. Okay, first of all, this is welcome all Broken Bakers and 13th jurors. We got raided by both right at the same time. Today is an awesome day. Broken Baker, you guys were following the same case we are with the Treehouse trial, I believe, which, Oh my goodness, is that crazy? It is absolutely nuts. It's yes, the defendant pro se is. Let me get rid of the replay button there. The defendant's pro se. He's I will say he's doing the best I've ever seen a pro se defendant do. I'm talking to one who's not a lawyer, okay? Because I've seen lawyers represent themselves in traffic court and they do really well. But as far as somebody who's not a lawyer, this guy is doing the best job I've ever seen. I still would say he should have an attorney. He should have a lawyer. He is struggling with the process and the procedures. His subpoenas are running out. He's not getting his witnesses scheduled on time. He can't get his evidence in order. It's been crazy. Let me say that. But before we go too far, for all the 13th jurors who are just joining, if you guys do not know, today was a huge day for Brandy. Brandy hit 15,000 jurors, 15,000 subscribers. Well, they're 13th jurors. Right as she was on lunch. It was actually, I started just a few minutes late on lunch because I was watching that. When she hit that was, and now it's official. They're coming in. So Brandy hit 15,000. It was amazing. It was awesome. She has put in a ton of work to get to that point. It's a huge threshold, a huge benchmark. And it seems sometimes it's like a watch pot never boils. So the closer you get to, you're like any minute now, and it takes forever. But it was just really, really cool to see Brandy hit that. She's put in a ton of effort. She's dealing with some tough things in life right now. She got dealt a crap hand, and she's doing just amazingly with it. And to see all your support for her, and Broken Baker's close to 2K. We've got to get you to 2K, Broken Baker. We've got to do that. We'll focus on that here. Brandy's just. To know her is to love her. She's amazing. We love her here. She's got a great channel. She has an amazing community that she fosters. What the quality of work she puts into her channel is incredible. We love it. So thanks to all those who support Brandy and helped cheer her on today as she hit a huge milestone, which is well worth celebrating. That is just awesome. We love it. Thank you. Congratulations, Brandy. All right, where we are on the Treehouse murder trial, yeah, we should be in court right now. We should be listening to testimony in defense from Travis, or not from Travis, from Tyrone Tucker's side. We should be hearing people saying all the good things about him and how it couldn't have been him. But no, we don't have any witnesses today because they canceled on him. The witnesses he wanted to start with tomorrow morning just got struck. The state moved to have that witness struck from the list and eliminated, so we can't call him. The judge asked him what you're calling him for. He told the judge, and the judge says, no, that's not admissible. We can't do that. I'm going to grant the state's motion. You can't have that witness. So he's not getting the lawyer who we wanted to testify. That means he's probably not going to get the evidence in that the lawyer was going to authenticate, which is the motion that he had filed for Travis, saying that his statements was made under pressure and it was coerced. So that's not going to happen. So his pieces, his brick house is tumbling down around him. But that being said, if he just rested right now, if he just closed, I think he's still winning this trial. He's winning. The jury still does not have enough evidence to convict him in this case. They may not like him. I don't think the jury is out there liking Mr. Tucker right now. But I don't think they're going to convict him because the evidence just is not there. It is very weak, especially when you have a lot of evidence from the crime scene, when you have DNA, a glove, a mask, a weapon, the victims who saw the attack and testifying. When you have all those pieces and you put it together, and none of them, like a big zero, point to Mr. Tucker, except for one guy who was admittedly involved in this and stands to receive a huge benefit from pointing the finger of blame at somebody else. So I just don't think they have it here. The state's not proven that, in my opinion. The Advocate, welcome to the gallery. Thank you so much. Appreciate you on your continued support of the program. Could we please get the Broken Baker link? Yes, let me give it to you here. It's easier if I provide it. Just one second. We'd love to see him get over 2,000 subscribers. Let me see where he's at right now. Right now, he's so close. I show 1,990 roughly. So let's get a link here. Copy. Let's just do nice things for people today, shall we? Let's see if we can have a few of you hop over here to the Broken Baker and just hit the subscribe button. And then when he goes live, check him out and watch some of his some of his lives and give some feedback and praise as it's due. It's a great channel. He as far as commentary, bringing in many different people and perspectives, he does a fantastic job at that. Absolutely love it. So if you haven't subscribed to Broken Baker, there's your opportunity to do that. And let's see if we can get him over the hump, so to speak. There he is. He's over. I showed 2,000, at least 2,040. Congratulations, Broken Baker. Congratulations on 2K. He's really funny. He's really funny. I appreciate you guys doing that. I don't think you're going to regret it. Obviously, I've told you a million times that my opinion when it comes to YouTube and LawTube and LawTube adjacent in general is that the internet is big enough for everybody. And just like I know we say pickles, not politics, but in politics, I'm a firm believer that the more people that participate, the better the outcome is. I think that when we're talking about trials and when we're talking about the law and crime and transparency and watching courts, I think the more people, the more viewpoints we have that we share and talk with each other, the better the result. So I'm a big fan of people who a lot of people would say are direct competitors to me. We're not competitors. We're all fans of the same thing, right? We're all fans of true crime. We're all to some degree students of the law, whether it's formally or just on the side. But anyway, good stuff. Thanks for your help over there with Broken Baker as well. He'll have to do a celebratory live stream tomorrow, I think, or maybe this afternoon. I'm not sure what his plans are. All right, Patty, sub to Broken Baker because RA told me to. You guys are nice. I'm just saying that you won't regret it. This is good stuff. The content they put out, the discussion, and oftentimes is very different than mine. Like the viewpoint might be very different. We might take completely opposite perspectives and even be cheering. I know in some cases, like Broken Baker, there's some cases where you guys are very strongly on one side, and I have been on the other of that case, and that is good. That is good for the community. That is good for us because we're able to have a civil conversation and discuss things. It works better. I love it. I love every bit of it. All right. Now we're going to, what are we going to do? We have no more of that. The Judge Boyd has gone silent out of her courtroom. Let's see. You guys are super generous. Thank you so much. Yes, we can get along with different views. Candace Hoff, I have hope. I know we just passed Martin Luther King Jr. Day, but I have a dream that what we have here in this community, with the way we're able to discuss things civilly with each other, can grow and spread to how we interact with our neighbors and with our our community members and with each other in government settings and at work and on the road. Yes, even on the road with road rage. I believe that what we're doing here isn't just in a vacuum and that it can actually spread. That's why we have the outro that we do, where I believe in doing a little bit for somebody else who's outside of us and our little circle. That's my dream. And I love to be proven wrong. That's why it happens so often. I am often proven wrong. I'm culperistic. I'm often just wrong. I'm often just like misled, misinformed, or have just come to the wrong conclusion in general. All right. That being said, let's see. Making law simple. Am I in the inside or outside are you talking about LawTube or LawTube adjacent? I think you get to sort of define your own place. I am definitely LawTube adjacent. I can tell you that. I think you might have a little more experience in that area, so that might put you as an insider. Let's see. M. Young says, I go to Broken Baker when I need to use cursey words that RA doesn't like, but YouTube will not demonetize. Thanks, M. Young. I appreciate that. We do have, surprisingly, you might say, we have a younger audience and an older audience. We have both. We have an audience that's more mature, and we have children that watch this. not just mine, not just my kids, but there are people who use this channel because of what we have here, because of the community, to show how the court systems work and get involved that way and just make them aware. Debate and respectful conversation helps with critical thinking. Critical thinking, absolutely 100%. Let's see, RA just called me young. Maybe? Yes. Yes, we're all young at heart, at least. And some of us are actually, I'm not speaking to myself, but some of us, meaning you, are actually young in body. All right, I've pontificated for long enough. Here's where we are. Trial's over for the day. Tomorrow is going to be incredibly spicy in the Treehouse trial. We know this because tonight or tomorrow morning, we are going to see a motion filed where Mr. Tucker is asking for the judge to be dismissed from the case because, he says, I'm not getting a fair trial here. We're going to have let me see. Oh, that's a different one. A disqualification motion is going to be filed either tonight or tomorrow, which will stop the judge from doing anything. Under Florida law, he has to do three things. The moment this happens, like when this hits his desk, okay, this is how urgent it is. The state law in Florida says he has to stop, drop, and rule. He has to stop everything he's doing on the case when he's served with the motion and not enter any new rulings on any other issues. He has to drop everything and review the motion for procedural and legal sufficiency within the four corners of the document. That's where I think Mr. Tucker stands to lose if he's not careful, because there's a lot of pieces that have to fit together in that. And then he has to rule. He has to prepare a written ruling granting or denying the motion no later than 30 days after service. So those three things. I believe that the third one can come very quickly, and it will probably come within an hour, because the judge knows it's coming and he can prep. He can do his homework all night, and then he just has to fill in the blanks. Oh no, I missed, Welsh Lady, I missed your milestone message, spreading the love. I am sorry. Let me see where it is. Did I miss it a long time ago? Oh, it's right here. It was right at the top. It was 5 messages away from disappearing. Welsh Lady says, I love this channel. Love and chat, you're the best. Thank you for your kindness, and RA, you're fantastic. Mods too. Much love to Mr. and Mrs. RA from Wales. Thank you, Welsh Lady. I appreciate you for the email you sent. It is very thought out, has a lot of information. As you've analyzed this, you're definitely a true crime fanatic. Love it. But congratulations. Love that blue courthouse by your name and the flower as well. All right. Anything else we need to cover? Let's see. We've got the Crumbly case. I think they're starting jury selection starting tomorrow. We might be jumping to that one if the Treehouse case wraps up, or we might go back and catch up to that one. Sheriffs, oh my goodness, this trial is nuts. Let me tell you this. There will be times when you're like, I don't have enough Advil in this house to continue listening to what's going on during this trial. There are times where you're just like, the deposition audio is bad cinema. It is so hard to watch. I mean, I'd rather scratch my fingers down the nail of the chalkboard and, I don't know, being Chinese water tortured. It's so bad. It's so bad to sit through. And then there are other times where you're like, did I just hear what I think I heard? And the judge going off, and Tyrone going off, and the Mr. Mansfield going off for the district attorney. And then I'm not even starting on getting into what actually happened outside in the investigation of this case, and who's been fired on the investigative team, and what police officers or detectives have been reassigned out of badge service. It's crazy. This case is nuts from the top to the bottom. It's got crazy facts all over the place. We've got famous or well-known people, as far as Mr. Tucker married a well-known businesswoman who co-founded CrossFit, Lauren, and she called in and talked to us. She called in and spoke to us and cleared some things up that I was wrong on. It was very insightful. Appreciate that phone call as well. It's been nuts from start to end. Cachette, thank you for the 5 gifted memberships. I appreciate that. As does Tisha S, Lovebug, Luna Noxumbra, Cherry, and Lisa Faltersack. Thank you very much. That was generous. But that's happening tomorrow, so it's not over. We probably will have another break tomorrow because of these orders. So first thing in the morning we'll start, and then we'll stop, and then we'll probably start again. And I anticipate. let me just say, I anticipate the judge ruling very quickly, like almost having his reply ready to go. It has to be written, but almost having it ready to go. So a very short break after it's filed. Here's your reply. Denied. Move on. No witnesses. Okay, go straight to closing arguments. We're going to have complaints. We're going to have motions and objections. It's going to be spicy, but that's how I see it going, because I just don't think we're going to have the witnesses that Mr. Tucker wants to have here in time. All right. You know what that means. The music has started, so we have to roll to a close here. Make sure I've got everything set up so we don't. Yeah, we're good. I have jury duty tomorrow, says Belinda. Tomorrow, jury duty. After you're done serving, we'd love to hear about it. We'd love to hear. There's the music, says Ashley. Tisha S., you're green. Now, if only 80s would hit that. Yeah, 80s has no luck when it comes to that. Brandy, oh my goodness. Brandy, thank you so much. Congratulations. Huge shout out to Brandy. 15,000 subscribers today. What a benchmark. If you haven't watched that stream, oh my goodness, get your tissues ready. Get a big box of Kleenex, wrap up in a blanket, and rewatch Brandy's stream from today. It is awesome just to see the generosity and the supportive community that's rallied around her. She deserves every bit of that and more. Thank you so much, Brandy. So great to call you a friend. Appreciate that. All right. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again. It will be tomorrow morning with the Treehouse murder update. It might be short, but it will be spicy. The judge might be asked to be disqualified. Well, he is going to be asked to be disqualified. Whether or not the case moves on from there, we shall see. But it's going to be great. You guys are amazing. Thank you so much for everything you do. We'll see you tomorrow. Be good to each other. Bye-bye.
Have them send someone with more experience.
Scratch all that. Oh, that was terrible. I apologize.